एक्स्ट्रा चश्मा रखी ना दी अच्छा हो केबे केबे रखिवा राइट item number 8 land council for the petitioner 6 for an adjournment list this matter in the week commencing from 5th August 2020
My lord, item 1. My lord, item number 18. Permitted to withdraw.
item number 18 it is 5029 of 2016
Yes, my lord.
WPC you have got power in this case
No.
so you are mentioning on whose behalf
We have Mr. Proceedings.
all right what is your good name
S.K. Hon'Ble.
Mr. S.K. Hon'Ble land council submits that he has been authorized by Mr. Prabhas Kumar Jena, Prabhas Chandra Jena, land counsel for the petitioner to make a submission for withdrawal of the writ petition. The writ petition.
One.
Huh? Acha, to acha, withdraw this case number so on, sir. So, this case number so on, so it's disposed of as withdrawn. Yes.
Item 1, my lord. I pray for 2 more ballots.
Tomorrow and next week, as you.
My lord.
There's this matter in the week commencing from 5th of August 2024. As great for lecture. Yes.
Pardon, my lord. My lord, 2022 matter, my lord, challenging the loaned DRT order, my lord.
Keep it.
Okay, sir.
With permission, one matter was posted to yesterday, but the matter has not been listed. Hence, this memo, my lordship. It has been the writ has been filed by challenging the order passed by DRT by the borrower and the opposite party auction purchaser.
Keep it.
That's all.
With my knowledge, these are 2 writ petitions I seek listing. They were supposed to be listed today. It was being heard by my Lord Justice Arindam Sinha, but now with the assignment change, these are connected with promotion. Yes, my Lord. Right.
Supplementary list item number 2.
I may please. The petitioner's challenge in this writ application, the order of Honorable Tribunal, Malad Central Administrative Tribunal, had annexure 8, which is starting from the page 34 of Malad's briefment. The fact of the case is that the petitioner's father was serving in the railway post. In 1974, by annexure 1, there was a notification circular where the persons who have not participated in the emergency strike, they have given certain benefits and they have been categorized as loyal staff members. Though that specific loyal staff is not been mentioned in any service book, but at that I have annexed the service relevant pages of the service book, which reflects that the petitioner's father was working in the year 1973-74 manner. Pursuant to that circular, the petitioner after his graduation applied for the post, any post in the railway court, and they have not considered this, and they have the petitioner challenged before the Honorable Tribunal. Tribunal directed by annexure.
How many times?
Tribunal, first of all, he approached before the Bilaspur High Court's mandate. As that was not the jurisdiction, he approached before the tribunal, Bilaspur mandate. At that time, relevant documents could not produce. That is why he withdrew the case and filed a right to information application before the authority for relevant documents. And as the relevant documents has been supplied to the petitioner, after that he approached the Honorable Tribunal of Cuttack Bench in the year 2023 manner. And in 2023, the Honorable Tribunal, without going into the merit of the case, directed the authority to consider the representation at face, which the order of the tribunal also I have annexure 6, which is in Malad's brief is page 30 Malad. And after the disposal of the Honorable Tribunals, the authority rejected the prayer and rejected the representation, which I have annexed annexure 7, page 32, my lord, in my lord's brief, my lord.
Come to that,
Yes, my lord.
why it was rejected.
My lord, annexure 7, my lord, page 32, my lord.
Yes,
I may be permitted to place the entire order, my lord.
yes.
Region speaking order in compliance of order dated 11/4/2023 passed by Honorable Cuttack Bench Cuttack in way number 168.
But you just come to the 1, 2, 3, 4.
Yes,
You
my
come
lord.
to that. Yes.
That in compliance, before that, my lord, the Wilman.
No, that is the operative part of the
Yes,
OA has
operative
been
part, my
quoted.
lord.
Yes.
Point 1.
Hmm.
It is the case of applicant that his father was appointed in Group D category on 18/7/73, that the father of applicant rendered his service during the strike that took place in the year 1974 and as such level as loyal staff, that the Ministry of Railway by its letter dated 13/2/1974 dated 9/7/1974 and dated 3/5/74 had extended certain service benefits to the loyal staff and also to their children.
What is the loyal stuff?
Loyal staff meant of those persons who have served at the time of emergency without participating in the strike, they are labeled as
Okay.
staff.
Yes. Yes. Then
That the father of applicant superannuated on 31/10/2015 from the post of senior good guard, applicant in the way prayed relief to extend the benefit of loyal staff quota by engaging him in any vacant post available under the establishment. Point 2. That admittedly the strike took place in the year 1974. The applicant who is seeking the appointment under the loyal staff was not even born then. His age is 39 years on the date of filing of the instant OA before the Honorable Cat Cuttack. In the later Railway Board, there was no such stipulation that appointment shall be given to the son and wards of the railway employee who took birth after the strike was over. The Railway Board, by letter dated 10/9/75, decided that Railway Board's letter dated 13/2/1974 should not be made beyond 31/12/1975. Since the applicant did not apply prior to 31/12/75, his case could not be considered. 3. That the cause of action in any case would arise to the applicant after a lapse of 1 year and the applicant had admittedly not referred any suit petition before any court of law in this regard with the period of limitation. Applicant approached for the first time before the Honorable High Court Bilaspur by filing writ petition number so and so in 2016 that stood dismissed by the order dated 2/12/16. Further, the OA number 102/17 before filed before the Honorable Cat Jabalpur bench also stood dismissed by the order dated 8/8/2017. The instant OA had been preferred after an inordinate delay of 49 years. 49 years after the strike. His time barred and any series of representation filed by the applicant and his father would not extend the period of limitation. 4. That the said scheme is one-time scheme and cases of son and daughters of the loyal staff has to be considered up to 31/12/75. 75 in terms of Railway Board's letter dated 10/9/75. That appointment on compassionate ground being an exception to that of the general recruitment, the same should be provided with all caution, taking note of the facts that compassionate appointment will certainly deprive the eligible meritorious youth and citizens of the country to get public employment. In view of the above position, the original application have been treated to be the representation in the instant case is devoid of merit.
so what is that scheme?
Scheme is a mallet and next to 1 minute. Not scheme, that is a letter mallet, circular.
No, it is mentioned that it is a one-time scheme.
Yes, that scheme they have not supplied any time, and they
No, but the something. Have you tried to when the order was passed and it is mentioned therein that there was a scheme which prohibits you to get the relief. Have you taken any steps to know what is that scheme and what is written there?
Malad, I have also tried to find out that scheme, but the petitioner could not find that scheme. But
No,
my
it is. Have you applied for any RTI that you to note
Yes,
that what?
that the petitioner applied, but that I have not entered.
Because your case, they are maybe based on that particular scheme,
Yes,
as they have stated
Yes.
that it was a scheme formulated and it was a one-time scheme, and that is to be taken into account of to a particular period, and by then you are not even born.
Yes, ma'am.
So if you are claiming a compassionate appointment on the basis of a particular scheme, but that scheme you have not seen, how did you then drafted this writ petition?
My submission is that manner before your lordship. Once the person has been categorized in a loyal staff manner, that is itself that.
No, loyal staff is all right, but for the legal representative or legal heirs of the loyal staff, if they want any kind of appointment, that is for that a scheme is there.
Yes, ma'am.
So if you are not coming within that scheme, how relief can be granted to you?
Lord, my submission is I am coming under that scheme. They have not.
That is why we are asking you what is that scheme.
The scheme I have not read.
Then how did you frame formulated the grounds, and how you are arguing the case that relief is to be given to you? Who is the appearing for the CGC? Is it? So what is that scheme particularly when this tribunal the chief personal officer has mentioned in paragraph, look at paragraph number 4. Have you seen that scheme? So then please bring that scheme, let us see. He has also not seen this scheme. You have not seen this scheme. The case has been dismissed basing on that scheme. So we want to know that what is that scheme in fact. Yeah.
One is that they have approached the Vigilance to High Court and subsequently.
That's a different matter. That's a different matter.
That has not been challenged. You also see in the last paragraph.
No, it's a question. Maybe that is maybe a question of jurisdiction. Now he has approached the right court according to. But the question is that when the tribunal has entertained the and said that the representation has to be disposed of, so the representation has been considered. So we cannot go back behind that. So we are to see that whether the representation has been dismissed, whatever grounds has been taken for dismissal of the representation for not getting the relief to the petitioner is justified or not. So for that, as we find on paragraph 4, one scheme has been referred. So you ask your officer to bring that scheme. Let us see what is there in that scheme.
Once the direction is issued by the tribunal to consider the representation and file a fresh representation before the open number 1.
Mr. Ka, whether the representation has not been taken or that way has not been treated as a representation.
Yes, ma'am.
So that is. So even if he has not filed any representation, the petitioner, but the OA has been treated as the representation,
Yes.
and the case has been considered and disposed of. But that is based on a scheme neither you have seen nor the London Council for the petitioner has seen. So in the ends of justice, we want to see that whether on the basis of that scheme, whether he was get that scheme,
Yes.
get that scheme. So we'll take up this matter in 12th August. Bring that scheme. Take down. This writ petition has been filed by the petitioner Santosh Pradhan with a prayer to was the order dated 2/1/2024 passed by the Central Administrative Tribunal in OA number 1 of 2024 by Annexure 8. With a further prayer to consider the case of the petitioner and extend the benefit of loyal staff quota by engaging him in any vacant post available under the establishment. The Central Administrative Tribunal Cuttack Bench by Annexure 8 rejected the original application mainly on the ground that the claim of the applicant is not tenable as per rules and is also barred by limitation. And the tribunal also did not find any illegality on the part of the respondents in rejecting the claim of the applicant by order dated 14/6/2023. The order dated 14 subparagraph, the order dated 14/6/2023 has been annexed to the writ petition as Annexure 7, which is passed by the Chief Personnel Officer bracketary IR, which shows that the original application filed by the petitioner before the Central Administrative Tribunal in OA number 168 of 2023 was treated as the representation, and the same was held to be devoid of merits. While considering the representation, the Chief Personnel Officer has taken into account a scheme and held that this is a one-time scheme and cases of son/daughter of loyal staff has to be considered up to 31/12/1975 in terms of Railway Board's letter dated 10/9/1975. Neither such a scheme has been annexed to the writ petition, nor the Learning Council for the petitioner or the Learning Central Government Council is having a copy of such scheme. Let the Learning Central Government Council produce the copy of the scheme on the next date, which is fixed to 12th of August 2024.
Some more time.
Okay,
20
20th of June. Yes.
That letter, that 10/9/75.
And also the Railway Board's letter dated 10/9/75.
Because it seems, my lord, Annexure 2 is the scheme that has been restricted by 10/9/1975. You lordship may kindly see as you lordship. The what the railway employee who took back after the strike was over, the railway board filed letter dated 10/9/1975. He stated that the railway board letter dated 13/2/1974 should not.
You mean to say that Annexure 2 is that scheme?
Yes. That is
Just
the scheme which has been restricted.
Be confirmed on that. Be confirmed. Okay. Be confirmed. Let us. Okay.
Because this scheme has been restricted for the period.
No, it's all right. If you say that this is the scheme, it's all right. We'll adjudicate the matter. It is coming on 20th, huh? Yeah.
Item number 3.
My lord, there was a surface action initiated against the petitioner. The petitioner had availed a loan for house building, and the admitted demand is 10 lakhs. I approached this honorable court with a prayer to settle the matter on OTS scheme. There was an order by this honorable court to settle to take a decision on my OTS application. My lords, now what they have done, my lords, they have added other loans in this account. But my humble submission is that, my lords, Surface Area Act is related to cases where there are secured assets. The secured assets was mortgaged in respect of the house building loan only.
So before you came to this court,
My lord.
13.4 was already issued to you.
My lords, 13.4, your lordship kindly
So after
see.
that you have come.
My lords, kindly see, in 13.4, even they have not stated what is
Is
the
there any
amount.
scheme plotted by the bank for one-time
My
settlement?
lords, there is a
Where is that? Before the 13.4 was after 13.4?
My lords, it is always open, my lords. So
why did you prefer that?
I
Before
preferred,
13.4?
my lords, I preferred. I applied them, my application.
So you applied only after the direction issued by this court.
My lords, earlier I had also applied, but this honorable court directed to take a decision on my application. My lords, my humble submission is that the OTS scheme is created by the RBI management. They have to act, they cannot choose, pick and choose. If some scheme is for benefit of the persons, should be done equally, no discrimination. And my application was that let this account be settled under the OTS scheme.
Now,
I am appealing for the bank, my lord.
come to your FAR portion.
My lord.
Your petition has been filed on 22/3/2024. And see the prayer to stop the bidding process, which is going to be held on 25/3/2024. So the 4 months have already passed in the meantime.
My instruction today, I have taken instruction. Nothing has proceeded. No person participated in
So
the bid.
if you have filed an OTS application, it's all right for the authority to come and if you have any grievance, approach the proper forum, because time without
The OTS
number-
has been rejected by the bank, my lord.
Yeah.
It has been rejected, the OTS.
Rejected.
Yes, my lord.
Then
My lord,
My lord, this is
that
the.
I have annexed that.
They have also intimated that.
so,
Already implemented.
Intimated
Intimated to, yes.
so that's different. Lekon.
My lords, I will approach the appropriate.
Yes, we are disposing of. The London Council for the petitioner submitted that earlier the petitioner approached this court in WPC number 3096 of कहते paragraph 10 ने देना थी of कहते सर
24.
2024 जो पेज टा मुझे टेलीफोन पे हाथ मार लगा and by order dated 13/2/2024 this court directed the petitioner to place an offer for OTS and the opposite party was directed what is that order?
Order, my lords, annexed 1, I have annexed that. Page 13.
Okay, the petitioner was अच्छा the during course of hearing लिख दियो तो देखिए annexure 1 लिखी हुई the petitioner withdraw the writ petition seeking liberty to file an application before the bank hyphen opposite party for consideration of the one-time settlement of the outstanding dues towards the loan availed by the petitioner. And the writ petition was disposed of with observation that in the event such an application is filed, the bank opposite party would do well to consider the same on its own merit and dispose of the same in accordance with law at an early date. In this writ petition, prayer has been made for a direction to the opposite party to stop the bidding process, which is going to be held on 25/3/2024. The writ petition was filed on 22/3/2024. When a query is made by this court to the London Council for the petitioner that what happened on 25/3/2024 and thereafter is submitted that he has obtained instruction that there is no further progress in the matter. However, the London Council appearing for the opposite party has produced the later dated so issued by so which indicates that the
Annexure 4, I have filed.
that the OTS, that the bank guidelines for OTS, the offer was not accepted in view of the bank guidelines for the OTS. Stop. The later produced by this one, so it's taken on reform. At this stage, the Land Council for the petitioner submits that the petitioner seeks permission to withdraw the writ petition to approach the appropriate forum. Accordingly, the writ petition is disposed of. Yes,
My name is reflected.
Mr. Arupananda Das, additional government advocate Lekhiven Khalil.
Item number 4.
Item
My item number 4. That is the petitioner. I heard the diary note, my lord, that thereafter the demand
auction was failed in this matter. Auction was failed. The deed petition now became infructuous. At them similar order will pass.
The Land and Council for the Mr. S.K.Sahoo Land Council appearing for the opposite parties. Sabu opposite party पे था?
My lord.
हाँ, opposite parties. Odisha Gramya Bank submits that though the prayer has been made to quash the annexure 2 and 3, which are the e-auction sale notice, but the e-auction has failed, and therefore no cause of action survives. In view of the submission made by the Land Council appearing for the opposite party, the writ petition is disposed of. Yes, next.
My lord, I have deposited the OTS amount, my lord. Before the authority, it is still pending, my lord.
Yes, approved.
In 8-12,
Not the settlement.
Sorry, you can appear whatever it may be. We will not entertain this type of petition. Yes, next.
Item number 5.
my lord, I am liberty to approach and
No liberty is necessary. Yes.
May it
Item
please, my lord.
number 5.
Lordship. Lords, under challenge is a termination of lease. The lease was granted with respect to a premises by the Odisha State Financial Corporation, my lords, to run my transport facility from there.
You are challenging Annexure 9.
Yeah, exactly, my lords.
Come
Okay.
to that Annexure 9.
41.
Yeah.
May I please, my lords?
Yeah.
In inviting reference to your letter dated 25/3/24 on the subject cited above, this is to inform you that as per the decision of the Board of Directors in their 400th meeting held on 6/10/23, notice was served to vacate the rented premises on or before 21/2024. Direct notice, my lords. Further, on your representation dated 7/12/23, matter was placed before the board meeting held on 28/12/23. After deliberation, it was decided to allow further time up to 31/3/24 for vacating the premises, but you did not vacate till date. In view of the above position, we would once again request you to vacate the premises and hand over the key by 36/24 as last opportunity. So it was placed on the board, my representation to that earlier termination notice to vacate, termination notice as well as to vacate was placed before the board. I was never called for, your lordships. Absolutely without preceding a show cause notice, this termination letter has been slapped on me. Now, interestingly, my lords, if your lordship takes page 28, annexure 4.
Yes.
I was holding a lease, my lords, with effect from 30th November 2019. That was a prior lease, my lords. That lease was extended on 1st of June 2023. The lordship has that, my lords? Page 28. 1st of June 2023. If your lordship takes the next page, 29, clause 1. The lease was for a period of 6 years with effect from 1/6/2023 till 1st of June 2029. Thereafter, if your lordship takes the first letter, which is at page 33, your lordships, 4 months after this extension granted to me, a termination notice is slapped.
Yes, you have not complied with the terms and condition of the notice, that agreement.
No, my lord, says no.
Then notice was issued to you.
No, my lord, the notice, if your lordship peruses, complains of no breach on my part. They simply rely, your lordships.
That is very much there in that. Why you have been asked to vacate the rented premises?
Lordship.
What is the that must be reason must have been assigned that you have not come to that there later. Where is that later?
As at page 33, your lordships, the first letter of termination and consequential vacation.
33.
Annexure 5.
Yeah. I'll read it. Let us see.
In inviting a reference to the above subject, this is to inform you that the corporation has let out the IDCO plot such and such on rent for a period of 6 years with effect from 1/6/2023. As per the terms, there is a provision in the agreement condition number 8 that in case either the lessor or the lessee desired to terminate the rent agreement can do so after giving 3 months advance notice in writing by registered post to other party, intimating their intention to do so, and on expiry of the time period so fixed in the said notice, the rent agreement shall be deemed to have been terminated, and the lessee shall deliver vacant possession of the scheduled property with all fixtures and structures of the lessor without any cost.
Just
now, my lord,
continue. Then next.
The Board of Directors, OSFC, in its meeting held on 6/10/23, have decided not to let out the plot. Plot had already been let out. The extent renewal deed was executed in my favor. Henceforth, my lords, in view of the above decision of corporation and terms of the rent agreement, we do hereby give you advance notice to you to deliver vacant possession of the premises given as rent on or before 21/2024. They are not citing any violation. Neither have I.
What did you reply to this letter?
The next page, my lord, page 34. Is my reply. So I say there, my lords, that I have invested sufficient amount of money for its development as per the terms.
No, condition number 8 doesn't require any reason to be given.
Lordship, my lords,
except a 3 months notice.
Lordship, that page 30, if you is pointing out, let me address on that, my lords. That clause 8 is a clause of termination at convenience, my lords.
Yes.
Now, my lords will appreciate that this being a lease given by a statutory authority, an agency of the government, this convenience cannot be said to mean at free will, whimsically done.
What you are doing in that plot or the land?
That's the shed probably.
It's a shed plot, my lords. I am running my transport facility there. I am using it for parking of the vehicles, loading, unloading. I have existing contractual obligations, my lord.
Okay.
4 months prior to the termination notice, my lease was extended.
Ajay, you have mentioned that what you have invested in that.
Lordship, in the letter.
Later.
That letter simpliciter was put before the board. The decision was reiterated. I have never given opportunity. Any breach complaint, if any, my lord, as per the board discussion, I can cure it or I will be subjected to penalty as per the provision of the agreement, my lords. Now that termination at convenience cannot be at their whims and fancies, but must be guided by the Wensbury principles of reasonableness and arbitrariness.
Who is for the other side?
Notice to OSFC. I
OSFC
have instruction to appear in this case on behalf of OSFC. Let a copy of the writ application be served so that I can take instruction.
Please give the names. It is the land council. Opposite party number 1 is the managing director OSFC.
Lordship.
For that you will appear. The second one is general manager OSFC. For that also you will appear. Third one is branch in charge, Bhubaneswar branch. Indradhanu Mari. It
is the OSFC in charge.
So for all the opposite parties you will appear. Okay. Mr. Amitabh Das, Land Council, submits that he has instruction to appear for all the opposite parties. Let a copy of the writ petition be served on the Land Council during course of the day. Matter be listed. We will take up this matter next week on 5th itself. Put up this matter on 5th of August 2024.
There is an IA also, my lord. No
We'll
queries.
see that.
My lord, may I also issue notice in the IAs that
See that. Let him obtain instruction.
Yes.
grateful.
Particularly, he's referring to that clause 8,
Yes.
that power has been utilized, because otherwise he has not defaulted anything. He has invested a lot in that land for his
And
business
what
purpose.
transpires that immediately after 4 months you are going to take a decision.
Grateful.
My instruction is that this land has been seized after section application of section 29. We have seized that land and we have given on rent basis.
No, but
All right.
it is all right. Rent you have given, but the man who has taken on rent has complied with the terms and condition. He made huge investment, and one fine morning will come, just go out. So
I'll take
that
instruction.
is.
What are the compelling
So who
circumstances?
will compensate that man? You are. It's not a private thing. It's
And it is not. You are a
when
government
you are government organization, and when you are giving a person, and just after 4 months, without any fault of his, you will just throw out. So
I'll
take
take
instruction.
instruction.
Yes.
Grateful.
Item number 6.
May I please? My lord, the petitioner challenging the order of rejection annex 3, order dated 10/1/2024. That the collector rejected my case that to enlist myself as a PDA, and he treated me, you are not PDF, you are PA for project affected person. PDF means project displaced person. Actually, I am a displaced person, my lord. The inquiry report 24 reveals that I have got my compensation amount for the house, land, everything. I have no claim anymore. If I will be enlisted like as a PDF, I will get the RR benefit as per the policy. Policy says that page 19, my lord. The policy clearly says that
What has been you have been declared as?
I have been
PA.
declared by the collector as a PA. My all causing brothers, they have declared
No,
me PA.
just what is the full form of project affected person?
Project affected person.
PAP or
PAF.
F?
Project PAP. Sorry, project affected person.
Project affected person.
And another is PDF. Project displaced
person.
Yes, ma'am.
So,
I am saying.
Oh, no, just a minute. Don't be so fast. Displaced persons. So this policy, this RR policy 2006, the benefits is available to that project displaced person.
Project displaced,
not the project affected person.
Yes, my
That is your submission.
Yes, my lord.
So how do you say that
yes,
the
my lord, my lord.
collector was not justified in treating you
Yes,
as
ma'am.
PAF instead of
Yes, my lord.
PDF?
Yes, page 24, my lord. Page 24, page 2. On verification of a award.
24, just
Yes, ma'am. Page 24.
No, where is page 2? 24 is there.
So, on page 24, clause number, the point number 2.
Yes. On verification.
On verification, the register of particular land so and so was passed in favor of Benudhar Bera, my father, late father, the son of Udainath Bera. He received the amount 3,000 so and so towards house. Categorically stated that house. I have lost my house. But collector has not reflected that I have lost my house. That effect, another document I have produced before their lordship in earlier occasion.
Towards house and tree value.
That not disputed.
That is not that.
That not disputed, my lord. I have received the amount. I am not. I am saying that.
It's not that. How do you say from that inquiry report?
Yes, my lord.
That from that number 2, it can be inferred that
only rejection point is my
you are a PDF.
Only rejection point is that.
Come to the
page 24 লেখা আছে last রে apart from the above Balaram Behera, the present petitioner son of Bendur have 2 buildings over the plot. Only this regime the collector has rejected. And to meet this query, Miller, this is the incorrect statement. I have given an additional affidavit to a letter inquiry report after disposal. For
No,
that-
no, just
Yes, ma'am.
let us come to the basic thing.
Yes, my lord. Basis.
Who is a person can be stated to be a project affected person? Is there any such
That is not a
definition?
person, that is a family.
Project
As a
affected family. Sorry,
I'm
That is
talking-
PDF and PD.
project displaced family.
Yes, my lord.
And one family,
My lord.
right? So let us see that what is that definition
My lord.
says. Give it. Why the- Project affected family or definition କୋଉଠି ଅଛି?
That is, my lord,
RR police ରେ
Orissa resettlement and
ଆପଣଙ୍କ ବହି କୁଆଡେ ଗଲା?
ମୋର
ମୁହଁରେ ଅଛି ସବୁ.
ନା ନା
ଆଉ?
my lord, I have annexed the policy.
Yes.
The page 19.
Yes, Mr. Das.
my lord.
Page 19.
Wait. Yes, Mr. Das.
Page 19.
Project has been in section 3.
157.
Project is defined 180.
187 re displaced family.
Just a minute. So displaced family definition is very clear that a family ordinarily residing
Yes.
in the projected area
Yes.
prior to the date of publication of notification under the provisions of the relevant act
Yes.
and on account of acquisition of his or her homestead land
Yes.
is displaced from such area or required to be displaced.
Yes.
Very clear.
Very clear.
So, do you mean to say that on account of this project,
My additional affidavit is there.
କଥାଟା ଟିକେ ଶୁଣି ସାରନ୍ତୁ.
Public.
Do you mean to say that on account of the project, you
Yes.
have been totally displaced from that area,
Yes.
or you are still residing in that area?
No, my lord, I am displaced after displaced in 2012. Spending the compensated money, built another remaining house on acquired area.
You see, compensation can be paid not only to the project displaced family, but also project affected family.
Yes.
Right or not?
Yes.
So the question is that whether when a policy says that the scheme,
Yes,
that
sir.
rehabilitation scheme is to be provided only to the project displaced person,
Yes.
so there lies the main aspect or the crux of the matter is there.
My lord.
So you are to satisfy us
Yes.
that you are a project displaced family.
Yes, my lord.
Yes.
And it's the additional affidavit that inquiry report clearly reveals that.
Where is that?
Additional affidavit I have filed, my lord. Yeah, earlier occasion that was produced, but the London court, the honorable court said that you file it with an additional affidavit. Page 3. Page 3. That was after the disposal of collector. For that reason, I have prayed it may be remanded back for fresh disposal.
Just so
Yes, my lord, I am placing. सरजमीन तदंत रिपोर्ट 10/4/24 दरखास्तकारी श्री बलराम बेहरा पिता वेणुधर बेहरा पारिपड़ा अनुरोध क्रमे गत 10/4/24 तारिखरे तांको घर को सरजीवन तदन जाई देखिले बुझिले जे खाता नंबर सोनसो डिसमिल ले एलए केस नंबर 25 ऑफ 2005 एवार्ड नंबर सोनसो जो गुडा एफर्ट हेछि सेपटरे द जनरल पावर कंपनी 2005 मसियाटर अधिग्रहण करछि एक्चुअली लैंड एक्वायर्ड बाय द कलेक्टर हैंडेड ओवर टू जेंडर आई हैव नो एलिगेशन अगेंस्ट जेंडर उक्त प्लॉट उपरे थिबा घर रे बलराम बेहरा पिता वेणुधर बेहरा तुला बेहरा माने माय मदर ବେଣୁଧର ବେହେରା ମୁନ୍ନା ବେହେରା ମାଇ ସନ୍ ଫ୍ୟାମିଲି ଏଣ୍ଟାର ଫ୍ୟାମିଲି ରହୁଅଛନ୍ତି ଆଜି ପର୍ଯ୍ୟନ୍ତ ସେମାନେ ବିସ୍ଥାପିତ ହୋଇନାହାନ୍ତି
ତାହେଲେ
ମାଇ ଲର୍ଡ ଆଇ ଏମ୍ ସେଇଂ ଇଟ୍ ଟୁ ଦ୍ୟାଟ୍ I have been displaced.
Sorry?
My house is still existing.
ଆପଣଙ୍କ
My submission is that my
you are
house is
relying on a
still
particular
The
Mr.
letter I am
Counsel,
reading.
you are relying on a particular document.
Yes, ma'am.
and
Letter
you
I am
have-
reading.
you
Letter.
have
Letter
annexed
your
it as
lordship will be
additional
conveyed.
affidavit.
Letter will convey.
When you are making a submission before a court and the court is asking you a question, you should have patience to listen the question
Yes.
fully and then
Sorry, my
answer.
lord. Sorry, sir.
Don't interrupt while we
Yes,
are
sir.
asking the question to you.
Yes. Sir.
This is not the way.
Sorry.
Yes, place that.
ବିସ୍ଥାପିତ ହୋଇନାହାନ୍ତି ଏବଂ ତାଙ୍କର ଏଇ ଘରଟି ଜିନ୍ଦଲ କମ୍ପାନୀର ସୀମା ପାଚେରୀ ଭିତର ପାର୍ଶ୍ୱରେ ଅବସ୍ଥିତ ଅଟେ ସେମାନେ ପ୍ରକାଶ କରନ୍ତି 2009 ମସିହା ଜମି ଘରର କ୍ଷତିପୂରଣ ରାଶି ପାଇଲା ପରେ ମୁଁ କ୍ଷତିପୂରଣ ରାଶି ପାଇଛି 2009 ରେ
ଆମେ ଓଡିଆ ବୁଝିପାରୁଛୁ ଓଡିଆ ଆମେ ବୁଝିପାରୁଛୁ ପଢନ୍ତୁ ଆଗକୁ
ପାଇବା ପରେ 2012 ମସିହାରେ ସେଇ କ୍ଷତିପୂରଣ ରାଶିରେ ଜିନ୍ଦଲ କମ୍ପାନୀର ସୀମା ପାଚେରୀର ଅପର ପାର୍ଶ୍ୱରେ ଯାଇଥିବା ରେଲ ଲାଇନ ପାଖରେ ଥିବା ଅବଶିଷ୍ଟ ଜମିରେ ପ୍ଲଟ ନମ୍ବର 16 ମୋଟ ଏରିଆ ଏତିକି ଡେସିମିଲ ଉପରେ ଘର ନିର୍ମାଣ କରିଅଛନ୍ତି ଯାହାକି ଫର୍ଦର ରେକର୍ଡ by 25/2 ରେ ଏତେ PR case number so and so the letter document is there my lord annexed enclosed here with the କାର୍ଯ୍ୟାଳୟ file number so and so ରେ real line ଅଧିଗ୍ରହଣ କରିଅଛି that house built house is also occupied by the railway ସେଟା ତାର notification ଟା next page 4 ରେ ଅଛି that was not taken into care of by the collector because this is the inquiry report after disposal of my case. So my humble prayer before your lordship.
Mr. Das, ये जो last line टा को सुन annexure
they are not
5
the
जो
additional. They will not.
ମୁଁ ଦେଇଛି ଆଜ୍ଞା କପି ଆପଣ ମୋର ରିସିପ୍ଟ ଅଛି ମୋ ପାଖରେ
give another copy.
ମୁଁ ଦେଇ ଦଉଛି
Give another copy. You just please see that annexure 5. This is the report of the revenue inspector and last 4 lines is very important. ଉପରୋକ୍ତ ପ୍ଲଟ ଗୁଡିକରେ ଥିବା ଘର ଓ ଜମି JSPL ଭାରତୀୟ ରେଲ ଲାଇନ ପାଇଁ ସମ୍ପୂର୍ଣ୍ଣ ଅଧିକୃତ ହେଉଥିବାରୁ ଉପରୋକ୍ତ ସମସ୍ତ ପରିବାର ଗୁଡିକ ସମ୍ପୂର୍ଣ୍ଣ ବାସହୀନ ସହିତ ବାସଚ୍ୟୁତ ଅଟେ ହେଲା ତ ଏଠି ଯୋଉ displaced family ଆପଣ କରୁଛନ୍ତି is either displaced or required to be displaced ଏଇ ଯଦି definition ଆସିଲା ତାହେଲେ why the petitioner
My lord, the railway will acquire something that is different, my lord. Now this is a company taken the land property of the petitioner, that is JSPL, my lord. My lord, kindly come to the order of the collector in annexure 3. Very clear, he has dealt with everything, my lord.
No,
this order was passed on 10/1/2024, right? And this revenue inspector's letter is dated 10/4/2025.
Just I want to
what is the cause basing on what this inquiry report has been filed at whose instance?
in the railway case my lord that Jindal fact has come to the fact knowledge
No. What is the authenticity of this report, sir?
Why such a report was given and whom?
Report, my lord.
Who has asked the revenue inspector?
My lord, in a railway matter, encroach matter, the present building, the remaining part रे मु जो compensation ए घरटा करिथिली.
All right, but you should have a authentic report. You just put out one paper from the railway department. It can't.
I pray, my lord. I pray, my lord. The fresh inquiry may be
no fresh inquiry. Why fresh
inquiry? They want the rehabilitation scheme as a project taken by the JPL, my lord. Jindal, my lord. My lord, now the report of the railway they are producing that will
their report is also saying that I have lost my house.
We are whose report it is?
They are reporting
why
joint inquiry.
We are asking you a question that why to whom this revenue inspector gave the report on dated 10/4/2024 on which you are relying on.
Manner after filing
So
this.
you claim it from railway.
Yes. No, I have no any dispute against the railway. A present case is against the land acquisition officer, collector, rejecting my prayer treating me as PAF instead of PDF. Because 24, the joint inquiry report, their document shows that I have lost my house and got the compensation. I am not disputing. I have received the compensation entire amount in LA case number 2005 and received in 2012.
Have you stated
Yes,
why RI?
Yes, my lord,
as
in
per
memo
this
of argument, in memo of argument, I have given, I have agitated before
My
the
lord, this is
collector
clear from
successfully.
the order, my lord. My lord,
My lord, page 16,
Wait,
page
wait.
16.
Land Council, please wait. Yes, Mr.
my
Das.
lord, the order of the collector, my lord, page 13. I'll place
Yes.
the last paragraph, my lord. Paragraph as per the inquiry report, my
Okay,
lord.
please
It is
place.
very clear, my lord.
Yeah.
As per the inquiry report of RI Amina, miscase number so and so arise out of WPC number so and so filed by the Balaram Behra versus state of others. The petitioner Balaram Behra, the son of the Benudhar Behra, is residing over the plot number 44 by 449 part. Isam Toila to number so and 43 by 433 part Kisam so and so under holding number so and so village so and so. On verification of award, register of village Paripara in LA case number 25/2006, award number 8 was passed in favor of the Benudhara Behra and son of Udaya Nath Behra, and he received rupees so and so amount and the towards the value of the trees standing over the plot number so and so. Area of so and so Kisam so and so. Award number 6 was passed in favor of the Benudhara Behra, Tinnath Behra, Vishwanath Behra, and Ukali Behra, Lakshmi Behra, and they receive amount so and so. Now, my lord, which is the over the land value numbers, plot number so and so.
Second.
Wait a minute, let me clear. The award number 10 was passed in favor of the Benudhar Behra, Tinnath Behra, Vishwanath Behra, and Utkali Behra, alias Uma Behra, Lakshmi Behra, and son daughter of Udanath Behra, and they receive rupees so and so
towards the value of trees.
My lord. Now, my lord, award number 12, my lord, was passed in favor of the Benudhara Behra, so and so and so and so, my lord. My lord, now last line, my lord. Sri Balaram Behra has another 2 buildings over plot number 44, Kisama and so on the balance area remains unacquired.
Yes.
As per the section 2D of the Orissa Settlement and Rehabilitation Policy 2006, displaced family means a family ordinarily residing in the project area prior to the date of publication of the notification under the provision of the relevant act and on account of acquisition of his or her homestead land is displaced from such area or required to be displaced. In the present case, the Kisam of the suit land in Toilet 2 and the family of the applicant has not been completely displaced by the project as discussed. Hence, the application is coming under the PAF, not instead of PDF.
Yes. My humble submission to your lordship in response to my Lance brother's query, the Tinnath Behra he read out, page 22, he has been declared PDF. My lord, page 20. Lordship kindly have a
ଆପଣ ପରା ଦିଟା ଘର ଅଛି ତାର ନଥିବ ଘର.
Sorry, Hajur. And I may have 2 house or 3 house. I have only 1 house I built that was lost in railway by railway. I may have 2, 3, but the law says that. Page 19, my lord, 18, 8, 2 and 83. The displaced family losing more than 2/3 of agricultural and homestead land, they are eligible. The displaced family losing more than 1/3 of agricultural land and homestead land, they are eligible. And I have lost my house, they are inquiry report. I am forgetting about my additional affidavit. They are saying that I have lost, my father lost my house. House from compensated ହେଇଛି. Our cousin brother Trinath also declared PDF. ମୋର 2ଟା ଜାଗାରେ remaining part ରେ ମୁଁ ଘର ତ କରିପାରିବି କାରଣ after displace ମୋର ଏବେ ବି ହାଉସ ଏକ୍ଜିଷ୍ଟ କରୁଛି. ସେ ହାଉସ ଟା ମୁଁ ଛାଡି ପଳେଇ ଆସିଛି କିନ୍ତୁ ସେ ମୋ ହାଉସ ଏବେ ବି ଅଛି ଜେଣ୍ଡାଲ କ୍ୟାମ୍ପସ ରେ ଯୋଉଟା ଏକୁଆଡ ଲ୍ୟାଣ୍ଡ ଉପରେ ମୋର ଏବେ ବି ଘର ଯଦି ଆଜି if your lordship will please to inquire they will get my house still existing because I have left. I've displaced. After 2012, I built another as my remaining plot, remaining area. That was I have lost in railway. That is additional affidavit showed. Even if if your lords will discard my additional affidavit, where a joint report page 24 saying that my father has lost a house, and I have received the amount. I am not denying.
So if your father has lost a house,
Yes, my lord.
and you have got two houses,
No, at that time not two houses.
so
At that
still-
time not two houses.
at
That
that time
was
we are
the-
not concerned. Now also you are residing. That is the observation made by the
page 22. Mala page 22. Mala kind have a glass page 22. Trinath Behera, their son Tilochan, everybody got really enlisted as PDF. Page 20 tanga na bhi achi. Page 20 re Trinath has been declared as PDF. My cousin brother, my elder father's brother.
जो प्लॉट कथा
My lord,
कलेक्टर रिपोर्ट रे उल्लेख अछि
my lord,
पेज नंबर 14 रे
my lord.
पेज नंबर 14 रे श्री बलराम बेहेरा has another two buildings over plot number 44 এটা লেখা আছে না নাই?
Yes, my lord.
ଆପଣ जो एडिशनल एफिडेविट रे जो annexure टी ଦେଇଛନ୍ତି
My lord.
ସେଥିରେ ସେ ପ୍ଲଟ ଉପରୁ ଆପଣଙ୍କୁ ସମ୍ପୂର୍ଣ୍ଣ ଭାବରେ ବିସ୍ଥାପିତ କରାଯିବ ବା ବାସଚ୍ୟୁତ କରାଯିବ ବୋଲି କୋଉଠି ଉଲ୍ଲେଖ ଅଛି?
ମୋର ତ 2/3 1/3 ଏଗ୍ରିକଲଚରାଲ ଲ୍ୟାଣ୍ଡ କରିକି
ଆପଣଙ୍କୁ ଯାହା ପ୍ରଶ୍ନ ପଚରା ଯାଉଛି
yes,
କଲେକ୍ଟରଙ୍କର ଫାଇଣ୍ଡିଂ ହଉଛି ଯେ ଆପଣଙ୍କର ପ୍ଲଟ ନମ୍ବର 44 if you can come to that order again once again page number 14 and the paragraph the last two lines which Mr. Das placed.
Yes, my lord.
Sri Balaram Behera, son of Benudhar Behera, has another two buildings over plot number 44 of Kisam Suwanso on the balance area.
Yes,
Hala?
my lord. Yes.
Eta achi finding.
Yes, my lord.
You are relying on an additional affidavit
My lord.
and you have annexed annexure 5.
My lord.
Annexure 5 ରେ କେତେ ଗୁଡାକ
Plot number 44 ବି ଅଛି
ଖାତା ଦିଆଯାଇଛି?
ହଁ ପ୍ଲଟ ନମ୍ବର 44/449 ଅଛି ସେଇଟା ସେଇ ପ୍ଲଟ ଟା ଅଛି
କୋଉଠି ଅଛି?
ପେଜ 3 ରେ ଆନେକ୍ସର 5 ପେଜ 3 ର ଆଡିସନାଲ ଆଫିଡେଭିଟ ରେ ଏଲଏ କେସ୍ ନମ୍ବର ପୂର୍ବରୁ ଏୱାର୍ଡ ନମ୍ବର 12 ଏୱାର୍ଡ ନମ୍ବର ପ୍ଲଟ ନମ୍ବର 44/449
ନାଇଁ ସେଟା ସବପ୍ଲଟ ଗୁଡାକ ଆପଣ
ସେଇ ଏଟା ବି ସେଇ 44/449 page 14 of read petition and page 3 read petition tallied my lord.
ଆପଣ ଆଉ ଥରେ please come to that page number 3 of annexure 5.
Yes, my lord.
ଖାତା ନମ୍ବର 12 ହେଲା
My lord.
ଆଉ 13 ତା ଉପରେ କେତେ ଗୁଡାକ ପ୍ଲଟ ଅଛି ଦେଖନ୍ତୁ including one of the plot is 44.
Yes, my lord.
Right?
Yes.
ଏଇ ପ୍ଲଟ ନମ୍ବର 44 ଉପରେ ଦିଟା ଘର ରହିଛି.
Yes, my lord.
ହେଲା କଲେକ୍ଟରଙ୍କର ରିପୋର୍ଟ ଅନୁଯାୟୀ ବା ଅର୍ଡର ଅନୁଯାୟୀ
ନା ଏଇ ପ୍ଲଟ ଉପରେ ହଜୁର ନାହିଁ ଏଇଟା ଏ ପ୍ଲଟ ଉପରେ ନାହିଁ 44/449 କଥା ସେ କହିଛନ୍ତି କଲେକ୍ଟର
ଆଉ ଥରେ ଆସନ୍ତୁ ସେଠି again you come to that
another two building plot number 44 of Kisam Talia on the balance area of remains unequal.
Right, so 44 number plot ଉପରେ ଦିଟା ବିଲ୍ଡିଂ ରହିଛି ଯୋଉଥିରୁ ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ
that I am disputing my lord. My entire humble prayer before your lordship that is disputed fact.
Come to the
so I pray my lord let I will make a detailed fresh appeal before the collector let it be disputed.
Come to page 24 the joint inquiry report by the Amin and Tahsildar and others my lord. There they have mentioned para 1
page 24
my lord.
That I am disputing.
Yes,
para 1 my lord.
Yeah,
the petitioner Balaram Behera son of so and so is residing over the plot number 44/449 part so and so and number 44/4333 etiki under holding number etiki so and so and the verification of the village she rohuchi actually age plot upare my lord. And last line is selection last part right apart from the above Balaram Behera have two building over the plot number 44 last line last paragraph କିସମତି on the balance area remain unacquired.
Actual,
जोटा
my
collector
lord,
reflect
the
କରୁଛନ୍ତି after the joint.
actual fact is that I have one building after compensation amount is
All right, order is up. Yes, next.
I pray my lordship may consider
Item number
that I
7.
have lost my entire land.
Back with your lordship.
No, I pray my that what I will take a praise prayer before the collector it will be
Yes, yes, next.
Back with your lordship, madam. That was a hard. Last day by your lordship, my lord.
Which
obliged.
matter? Ajay, it is inadvertently listed. It was disposed of yesterday, so wrongly listed. So no order is to be required to pass in item number 7. Yes.
Item number 8.
Item number 8 पर से time मागिले 5 तारीख दिन
8 नहीं mention at
Item number 9.
ତାଙ୍କ ପାଖକୁ ତାକୁ ଗୋଟେ ଲିଷ୍ଟ ଦଉନ ସେ ମେନସନ ହଉଛି ବୁଝିପାରୁନି ନା yes item 9
9 million representation on lecture 4 is pending. Yesterday matter was there, similar matter item 21.
all right representation ए जो 3 मास जो item number केते थिला yesterday 21 थिला से all right
Item number 10.
May I please, Your Lordship? The Annexure 5, page 20, the EXN notice is under challenge, Your Lordship. The petition is a widow lady, Your Lordship, avails 2 loans, mortgage loans, 2 loans, one for business purpose and one for house building loan, Your Lordship. And since 2016, the loan availed and the last EMI was
e-auction matter.
My Lordship.
Go to the appropriate. Yes, disposed of.
Yes,
alternate form is available. Yes, next.
Item
11, Mr. Prahlad Sahu.
May I please, Lordship?
Yes.
Lordship, he will approach the bank, Lordship, by making some payment, Lordship.
No, anything you want to say, so say before DRT. Yes. Next.
My lord, this is the second round litigation, my.
Yeah.
Without paying any compensation, without initiating any land acquisition proceeding, my lord, the opposite parties have been functioning Brahmana Pada Gram Panchayat office, my lord, for which the petitioner earlier approached this honorable court, my lord. I have annexed annexure 2, my lord, running page 22, my lord. This honorable court, after hearing both the parties, passed the order, para 5, my lord, your lordship may kindly see. Running page 22.
Yes.
Para 5. As agreed by learned counsel for the parties and after going through the records, this court, without expressing any opinion on the merits of the case, disposes of the writ petition directing opposite party number 4 to consider the representation filed by the petitioner by annexure 4 and pass appropriate order in accordance with law, taking into consideration annexure 3 series within a period of 3 months from the date of production of a certified copy of this order. Thereafter, the order was submitted before the opposite party number 4, collector, my lord. Collector has passed the order, my lord. That is at annexure 3. It starts from page 23, my lord. The lordships may kindly turn to page 24, last paragraph, my lord. After carefully examining the record, hearing the petitioner and his advocate and going through the papers made available to me, I am of the opinion that direct purchase can be done under the provisions of Land Acquisition Act and rules for regularization of the matter. The BDO Chokapat be asked to take initiation for the purpose. This order has been passed long way back on 4/8/2023.
Then what
But
happened?
they are not.
You submitted a representation.
Yes, my lord. Subsequently, I
that is,
submitted the
you have not
representation
got any response.
No any response, my lord.
All right. In pursuance of the order passed by this court, in WPC number so and so, the collector disposed of the matter on 4/8/2023 wherein it was observed as follows: कि paragraph here, last page 24 operative portion. It is submitted by the land council for the petitioner that representation by Annexure 4 was filed before the BDO Chakapad block in the district of Kandama, highlighting the grievances. But the BDO के कितने number opposite party?
OP6 मिला.
But the opposite party number 6 has not taken any action on so and so. So it disposed of within 3 months. कर दिया उनको, है ना? Yes.
Item number 12.
On the date of production of the certified copy of the.
May I please, Your Honor?
Yes.
The present case, the petitioner is challenging the notice issued by the land acquisition officer in minor irrigation department. And the objection, even though the objections are pending, the opposite parties are trying to disburse the said amount. The fact of the case are like this: the ROR, Annexure 1 is the ROR, which has been recorded in the name of Jagannatham, and thereafter the present petitioner's father has filed a suit which is pending and which is under Annexure 2 Your Lordship. Thereafter one IA has been filed under Annexure 3, and thereafter after bifurcation, the Civil Judge Senior Division Dharmagad, it has been Civil Judge transferred to Civil Judge Senior Division Joypatana. Thereafter the petitioner has absolutely no knowledge about the said fact, and it has been dismissed. And thereafter the petitioner, after knowing the notice, and filed the application for restoration, and which is pending, and Annexure 7 is my objection.
You know, if the compensation amount is to be paid as per the direction what has been given by the civil judge.
No, my lord.
Then
It has been
not yet
application has
adjudicated.
been
Not
made.
yet adjudicated.
Yes,
Not
yes,
yet.
well, not yet.
Only
So?
given messages.
He has filed a suit.
So why you are apprehending that it is to be disbursed to the other opposite parties number so and so?
My lord, may kindly see Annexure
3
5.
to 5?
Annexure 5.
Yes.
There it has been written in disposal of the IA number so and so, it was pending before the Dharmagad. Plus, I may be permitted to place.
Yes.
ଏହା ଦ୍ୱାରା ଦ୍ୱିତୀୟ ପକ୍ଷ ବ୍ୟକ୍ତିମାନଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଅଛି ଯେ ମୌଜା ପାଣ୍ଡରା ପାଖନା ଖାତା ନମ୍ବର 19 ଉପରେ ଥିବା IA କେସ୍ ନମ୍ବର 810 କୁ ମାନ୍ୟବର ସିଭିଲ ଜଜ୍ ସିନିୟର ଡିଭିଜନ ଧର୍ମଗଡ଼ କୁ ଆଦେଶ ମୁତାବକ କେସ୍ ଖାରଜ କରିଦିଆଯାଇଅଛି। ଏଣୁ ପ୍ରଥମ ପକ୍ଷ ଦ୍ୱିତୀୟ ବ୍ୟକ୍ତି ମାନଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଛି ଯେ 16/5/2024 ତାରିଖ 10ଟା ସମୟରେ ଭୂ ଅଧିକାରୀ ଉପର ଇନ୍ଦ୍ରାବତୀ ଜଳସେଚନ ପ୍ରକଳ୍ପ ଅଦାଲତ
ତାପରେ କଣ ହେଲା ଖାରଜ ହେଲା ପରେ କଣ ହେଲା ଆପଣ
I have filed application for restoration, my lord.
So what has been passed or what order has been
My lord,
passed
that
on your
notice
application?
notice has been issued, my lord. Notices has been issued to the opposite parties,
Yes.
but not till that it has
So
not
you
been
can
restored.
bring it to the notice that the matter is still sub judice. It is not been your
Yes, Your Lordship.
application is pending for
Yes, Your
consideration.
Lordship.
Notice as
Annexure 7, Your Lordship.
Annexure 7. So if that is there, so in spite of that, if the any order is passed disbursing the amount and ultimately you succeed, then there is, I think, provision is there that can again be recovered from the person who has been taken those money or
In fact, my lord,
in whose favor it has been passed.
admittedly the notices has been issued in the name of dead person. That Monu
No, why are you apprehending that after you filed the representation before the land acquisition officer, that the case has been reopened or the whatever it may be, he will, without waiting for the result of that, when the court has issued notice, he will disburse the amount. This is just an apprehension. As you said, your prayer is that not to disburse the amount to opposite party number 3 to 5.
Yes.
The decision was taken for disbursement because the IA was dismissed. Now you have filed another interim application, and in that interim application notice has been issued.
Yes,
You have brought to the notice of the concerned authority.
Yes.
So why you are apprehending? Why this court will pass the order not to disburse the amount?
Well, my limited prayer before the
It may be that your interim application, which has been filed before the civil judge, might be dismissed. Maybe.
No, if
We do
any
not
such
know.
situation is also there and emergent situation occurs, you file Rule 3. Order 1, Rule 2, Rule 3, you can file.
My limited.
Why again?
Annexure 7 is.
And that was filed in the month of May.
Yes.
Now we are in end of July. Nothing has happened. Why? Rightly, it has been pointed out by my senior.
My limited grievance, Your Lordship. In pursuance to notice, I have filed Annexure 7 before the authority. Let that authority will decide.
But are you debarred from filing Rule 3 petition? In case still the petitioner appears, you can get an status quo order. Because you have already moved to a forum.
Substitution is
And
also
you
there.
have rightly moved to a forum.
Yes, Your Lordship.
Why again another forum is to be utilized?
In fact, for ignorant, the petitioners are suffering, my lord. It has been before the civil judge senior division Dharmagarh.
All right, because new court came,
It has been transferred to thereafter the petitioners and the advocate has not informed the petitioners, and thereafter it has been dismissed.
No, it's all right. The court can restore the application, can rehear the matter and pass appropriate order. So question is that what has been pointed out to, why have you not taken that recourse and why have you come rushed to this court by filing in this writ petition, and why will issue a direction when even if more than 2 months have already passed, the authority has not disbursed any amount in favor of OP 3 to 5. So your apprehension seems to be that the authority has taken care of your representation, and that is why he has not disbursed the.
Only, my lord, my lord, at least my lordship may take a
Annexure
decision.
1 is very clear that 345 is the legal head of annexure.
No, we are not entering into that. We are not entering into that.
There is no dispute.
Let
And
me
for that,
are the learned counsel for the petitioner, learned counsel for the state. The petitioner Sudhanshu Shekhar Thakur has filed this writ application with a prayer for disposal of the Annexure 7 within a stipulated period, and with a further prayer not to disburse the compensation amount in favor of opposite parties number 3 to 5 pursuant to the notice dated 8/5/2024 under Annexure 5. The learned counsel for the petitioner submitted that after the order dated 14/9/2023 was passed by Senior Civil Judge Jayapatna in CS case number 220/117 of 2018-23. The opposite party number 2 has issued notices by Annexure 5 to the opposite parties number 3 to 11, है to remain present. A notice dated कर दियो तो 8/5/2024 to remain present on 16/5/2024 to place their case. The learned counsel submitted that a petition under Order 9, Rule 9, read with 151 CPC has been filed by the petitioner before the concerned court on केबे फाइल कले petition टा
26/6/2014.
26
6 26/6/2024,
which was registered as CMA number 11 of 2024 for setting aside the dismissal order dated 14/9/2023 and to restore the suit to its original file. And in that CMA application, notice has already been issued to the opposite parties. Simultaneously, the petitioner has submitted a representation before the opposite party number 2 to hold the payment of compensation with regard to LA case number 1 of 2017 till disposal of CMA number 11 of 2024 pending before the London Senior Civil Judge Jay Patna. The London Counsel for the petitioner submits that there is every likelihood that the compensation amount will be disbursed in favor of opposite parties number 3 to 5, and therefore he has approached this court by filing this writ petition. When notices have been issued to the opposite parties to remain present on 16/5/2024 to place their case, and after the objection was filed on 27/5/2024 as per Annexure 7, till date no disbursement has been made, no disbursement of compensation amount has been made in favor of opposite parties number 3 to 5 pursuant to the notice dated 8/5/2024. The apprehension of the petitioner seems to be totally misconceived. However, since the petitioner can seek appropriate remedy before the London Civil Judge Senior Division Jayapatna in CMA number 11 of 2024 by filing appropriate application for non-disbursal of the compensation amount in favor of opposite party number 3 to 5, we are not inclined to pass any order in consonance of the prayer made in this writ petition. Accordingly, the writ petition is disposed of. Yes.
Item number 14.
The petitioner seeking direction to the Central Administrative Tribunal to dispose of the OA filed in the year 2020, Mandate 152 of 2020, which is stipulated here. The applications relating to
What is the stage now?
Stage as hearing. I have given the status report. Pleadings has been completed. It has been adjourned only for hearing time to time. Page 75. I have given last occasion it was posted on 29th July. Again it was adjourned.
बहुत पुराना मैटर थी आपण मैटर टाकू एमती आमे जदी एंटरटेन करिवु 2020 मैटर टाकू डिस्पोज ऑफ कर दियंतु गोटे टाइम
cover matter by order of the similar order already passed by the Central Tribunal, and that has been confirmed by this Honorable High Court also. And this is a medical.
If it is a covered matter, you make a mention before the court, and the court will consider the same. Why this court will pass a direction to the Central Administrative Tribunal to dispose of it within a particular time limit.
May I permitted to file an application for any disposal?
Why do it? This writ petition has been filed by the petitioner so and so with a prayer for a direction to the Central Administrative Tribunal, Cuttack Bench, Cuttack, to dispose of OA number 152 of 2020 within a stipulated period. The London Counsel for the petitioner submits that the pleadings are complete and similar matters have already been disposed of by the uh, Central Administrative Tribunal, and therefore he may be permitted to move appropriate application before the learning tribunal for early disposal of the case. If such any application is filed, the same shall be considered in accordance with law. Without, we are not expressing any disposed of. Yes, next.
My lord, our appearance will noted, my lord. I am appearing for Union of India, my lord.
India ନାଁଟା ଲେଖିଦିଅନ୍ତୁ।
ବେଶୀ ଅସୁବିଧା କରୁଛନ୍ତି ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ।
କଣ
ସେ ଯାଉନାହାନ୍ତି କେସ୍ ଆଡଜଷ୍ଟ ହେଉଛି।
ମିଷ୍ଟର କାଉନସିଲ ଆପଣଙ୍କ ନାଁରେ କଣ କହୁଛନ୍ତି ଟିକେ ଶୁଣନ୍ତୁ। ଆଚ୍ଛା, ଓକେ।
My lord, it is pending before the tribunal. My lord, I am in High Court, my lord. I am appear all these cases, my lord.
No, what your left hand is doing, your right hand do not know. That you mean to say. So you instruct such a petition has been made. So make a discussion with the counterparts. We are there in that before the Central Administrative Tribunal to cooperate so that it matter can early
dispose of. Yes, ma'am.
Similar matters have been already adjudicated and it is a covered matter. So instruction, Mr. Padi.
My lord.
Mr. Padi, please unmute karantu. Mr. Padi.
Sir, kindly unmute.
Yes, unmute. Yes. Communicate to Mr. Padi that.
Yes, my lord. Yes, my lord. I communicate.
Just give a ring to him and let him.
Yes.
Yes, my lord.
Mr. Padi, we are now taking off this item number 13.
70.
Item
Yes.
number 13. This is WPC number 18010 of 2024.
My lord.
Right. So the petitioner has come to this court for a direction of early disposal of a particular OA before the Central Administrative Tribunal. It is his that the similar matters have already been disposed of and it is a covered matter and it could have been disposed of, but the counsel who is there in the Central Administrative Tribunal is not cooperating with the tribunal for which delayed disposal. So we ask.
No, my lord. Already representation disposed of. So he is, if any other cause of action, he can go and file before the tribunal.
No, just ask the counsel who is there in the Central Administrative Tribunal to cooperate if any such because the counsel is.
Everybody is cooperating. I think it is not a proper allegation against the
that is the submission made because if it is a covered matter, there is
maybe a submission, but it is some other counsel will appear and conduct. Some other counsel out of 40 counsels, anybody can appear.
Bring to your notice. That is all. We just bring it to notice.
Definitely, man. I will oblige, my lord. Definitely, I will take care.
Okay. Next case.
Item number 13.
Yes, Mr. Swine.
My lord, the petitioner pressed for to give the compensation in favor of the petitioner. So the petitioner, the land out to person. The land had been acquired by the opposite parties, my lord, that is Mahanadi Coalfield Limited. But the notice, the compensation notice has not been issued in favor of the petitioner till today, though the award has been compensation award has been finalized by the opposite party number, my lord, that is the.
When your land was taken away, that you acquired.
My lord.
What is the year?
My lord, that is the year, my lord, since last, my lord, in the year 1990.
What is the khata number, plot number, area? Where have you mentioned in your
1 and 2, my lord?
Annexure 1 and 2. This has been acquired by the opposite party number?
That is, my lord, Mahanadi Coalfield Limited. That is opposite party number 2 to 1 to 2, 3, my lord.
2 and 3. Okay. In which year it was acquired?
Money acquired in the year 1990, my lord. But till today, the award has not been
You have not received any compensation or received a part of compensation. You claim more.
My lord. Till today, no compensation.
No compensation has been received by you.
My lord. So
Okay. You have submitted a representation before whom?
That the opposite party number 4, who is the additional district magistrate, we have a resettlement, who will disburse the compensation amount in favor of the land of the person.
All right. The Land and Council for the petitioner submits that the petitioner's land has been acquired by the opposite parties number 2 and 3 since 1990, and the details of the plots have been given in paragraph number 6 and 9 of the writ petition. It is submitted that till date the petitioners have not received any compensation from the authority, for which a representation has been made before the opposite party number 4 by Annexure 3 on 24/5/2024, and direction may be issued to the opposite party number 4 to dispose of such representation in accordance with law. The Land Council for the state has no objection to such prayer. Considering the submission, 3 months time granted. He has to, from the date of production of the certified copy, and order to be communicated to him. You are appearing for
Union of India 1.
Union of India 1. The council is appearing. Please give your name. Sleep, just give it.
Let him serve a copy so that I will communicate.
Just give a copy so that he will communicate the order, and you will also produce the certified copy. Okay? Yes.
Item number 15.
Petitioner before your lordship is a loan. This honorable court at page 12, your lordship may kindly see the order passed by this honorable.
Read out the order.
Madam?
Read out the order.
Yes. In course of hearing, learned counsel for the petitioner prays for withdrawal of this petition. This petition seeking liberty for the petitioner to file an application before the bank opposite party number 2 for consideration of the same, consideration of one-time settlement of the outstanding dues towards the loan availed by the petitioner. Granting the liberty aforesaid, the writ petition is disposed of. In the event such an application is filed, the opposite party number 2 would do well to consider the same on its own merit and dispose of the same in accordance with law at an early date.
Yes.
Pursuant to this, my lord, I filed a representation under Annexure 1 at page 9.
Yeah.
Requesting them to settle the amount in OTS.
Yeah.
That was allowed, madam. That is at Annexure 3, page 14.
Yeah.
My lord, they settled it at 22 lakhs. At the time of application, I had deposited 2,50,000. That receipt I've given under Annexure 2 series at page 13. Now, my lord, this was communicated to me in WhatsApp on 4/5/24, but the letter came to us on 28/5/24. My lord, my entire endeavor before your lordship is that I will just 1 month time may be given, I will pay the entire money. This is my entire grievance before it. Because if 4/5 is taken, which has been sent in WhatsApp, then 4/5/4/6 4th of August is the last date. If 28th is taken, then 28th August will be the last date. I am ready to comply the OTS amount, but just 1 month is required because it is already settled.
You approve the authorities, if they extend, it's well and good. Mr. Sahu,
My lord,
what is your instruction in this
my
matter?
lord, regarding the date, the subsequent date, that is 20th May 2024. Yes. Within that time period, let them pay the.
Yes, if it is 28th for 28th August, my lord, I have nothing, no grievance. I'll pay, my lord.
So you approach the authority. We are not passing any order. So if you, for your relief which you are seeking for, you approach your authority.
Your lordship may pass that order. I'll approach the authorities. If they extend, I'll pay the money. That will do, ma'am.
Prayer has been made like this, and the order submits that extend 1 month time to comply OTS orders, right? Dated so and so under annex shall be passed by the opposite party. It is up to the petitioner to approach the authority to make such extension. We are not expressing any opinion on the same. Accordingly, the petition is disposed of. Mr. Tunasau submits that if the petitioner approaches the authority, they may consider the same granting extension in view of such disposed of. Yes.
Grateful, ma'am.
Item 16.
Item 16 and 17. Both are lordship, similar. Lordship, can you take out the second matter so that I have annexed proper documents? It can be considered. There is 18143 second matter, lordship. I have annexed some relevant documents which can help me, lordship, to convince a lordship. Lordship, I have permit to place the second matter, lordship. Item 17, lordship.
Yes, please place,
lordship. Lordship, in fact, lordship, kindly have a glance to annexure 1, page 17. That I have
what is your prayer in this repetition?
My prayer, lordship, annexure 1 can be, if it can consider, then it will suffice, lordship.
No, you are praying to pass
lordship,
order
that
dated.
is coming on the way. 14.1 application, lordship, under the act. The collector has given direction, lordship, kindly come to annexure 2, page. That's page 18, lordship.
So you are challenging this order dated 2/4/2024.
2/4/2024, lordship.
That was
under section 14.1 of the Surface Act 2023.
Just tell us that whether there is any alternate forum available to you or
my
not.
humble submission, lordship, I am at annexure 1.
Yeah.
Lordship, I don't want to test that validity of that order.
You are challenging a particular order as per your prayer. That is the order dated 2/4/24 under annexure 2. We are putting you a question whether alternative forum is available to you to challenge this order or not.
Yes, lordship.
That is, then go to the alternative.
No, lordship. Lordship, kindly come to second part of the prayer, lordship.
Yes.
Lordship, my prayer.
That relief is in the second part, which you are claiming that lordship can also be given to you by that appropriate forum.
But reason being, lordship, kindly, why I have approached lordship, kindly I have shown in my writ application. Lordship, in fact, lordship, second.
Time without number, you know, Mr. Dalai, that the Honorable Supreme Court and this court have stated that when alternative forum, in particularly in these matters, are available, don't entertain the writ petitions.
But lordship,
and even they have gone to the extent of saying that in spite of our order, lordship, the High Court. So that is.
I'm conscious, lordship. I'm not on the.
You are. So that is why.
Lordship, what
otherwise, you know that this court was granting that. It is not that we are granting such relief, but this is in view of such type of observation which has come. We are not passing any order now.
But lordship, kindly look at my
this
lordship, one line, lordship.
Yeah.
Because I have rushed lordship, because lordship, I have filed a surface application. But the lordship, kindly see the annexure 1, they have passed.
Oh, you have already approved the authority?
Yes, lordship.
All right.
No,
the land council for the
lordship.
Yes.
Lordship.
What is your number? That number you.
Lordship, that today, lordship.
You have today filed.
I have
Mr. Dalai, Land Council for the petitioner submits that the petitioner has prayed to pass the order dated so and so annexure 2 and for other reliefs, and seeking the same relief, he has already approved the DRT today, and therefore we are not inclined to entertain this. Since we already approached the alternative forum, we are not inclined to entertain this writ petition, which is disposed of. Yes, next.
Lordship, one thing, Lordship, I have lost only due to Lordship.
Go there.
Today, Lordship, kindly 1 minute, Lordship.
Yes.
Today they are coming for position. That is whole difficulty.
Yes.
That's why, Lordship, I filed
Just,
and I
just
mentioned.
file an interim application.
I said, only Lordship, protect me for 2 days, Lordship.
No.
Only protect 2 days so that I can move there.
Once we hold that it is not maintainable, you have already approved the other forum. We cannot pass any order in which we have stated that it is not maintainable. Yes, next.
But Lordship,
Next year, this item 16.
16,
Yes,
but Lordship only. Rider than the Lordship. In the meantime, give me some liberty to approach the authorities. So that at least
we expressed our difficulty. Otherwise, we are entertaining this type of application. We are granting, but since the orders have come, so we are not. Yes, next item number 19. Yes. Why item number 19? Very in person. Kalpana Das is he there?
Excuse me. Item number 18. Adjournment.
Item number 18 withdrawn.
My
So
name.
your acha. Item number 18 prathamaru jo withdrawn is the presence of Mr. Tuna shall be noted there. Okay. Yes. In the first hour he has withdrawn it. Okay. Okay. Yes, Kalpana Das in person is there. Nobody is there. Lekhantu, the petitioner is not present. The stamp reporter has pointed out some defects. Let the defects be removed by the petitioner. And after removal of the defect, the matter can be listed, may be listed. Yes.
Item number 20.
Item number
Item
20.
21 ମୁଁ ସେକେଣ୍ଡ କପି ଦେଇଥିଲି ଇନିସିଆଲ ଯେତେବେଳେ ଥିଲା ସିଙ୍ଗଲ ବେଞ୍ଚ ର ଥିଲା କିନ୍ତୁ ସେକେଣ୍ଡ କପି ସେତେବେଳେ ଦେଇଥିଲି ପୁଣି ରିପୋର୍ଟ ଆସିଛି ଯେ ସେକେଣ୍ଡ କପି ନଟ୍ ଫାଇଲ୍ ଆଇ with your lordship permission I file it today in court.
All right, the Learned Counsel for the petitioner filed the second copy of the writ petition, which is taken on record. Yes.
Okay.
Nothing further is to be passed. The order is already there. Item of it is undertakes to file the second copy.
Okay.
So it has to come now for admission or what? What is your prayer in this writ petition, Mr.? Cancelling resumption of this one.
So much proceedings.
This is no SR. We just want to see that any other defects are there.
Okay.
Please resumption from nothing second copy. Just SR has not been made or what? SR Koruna. All right. The stamp reporting be made accordingly. Yes.
Okay.
Weekly list item number 25.
Mr. Sharada Prasad Das. Kali Dokala will not feel
Right. He has prayed for adjournment to today, my lord.
Acha.
It was taken on Monday. He prayed for today, your lord.
हाँ ताले weekly risk करने
नहीं କରିଥିଲା ଏଟା 25 ଯାଇଥିଲା adjournment
let it come next week. We'll just अनापियस करके next week कर दें.
Item 27.
Please, your lordship, my lord, kindly taken up next week, my lord.
Yes.
Next week, my lord.
Okay. Next week.
Item 32.
I may be pardoned to mention, my lord. Item 33 of the weekly list might have been overlooked, my lord.
We are in 32, Learned and Council. We'll go to your matter. Best wait.
Pardon.
May I please, my lord. My lord, I had placed the matter. I'm
Please use the mic properly. Yes. Mr. Das is telling that you have enclosed their area. So
my lord,
please come to this side.
Sir was
Yes, sir. Please come.
Sir, good disclose question. My lord. In fact, he complained. He said that you have.
No, it's all right. Argue the matter now.
May I please, your lordship? My lord, on Monday, the matter was taken up. I had placed it for your lordship that in view of the guideline issued under Annex 3, pursuant to the observation of the Honorable Supreme Court of India, the very initiation of the proceeding on the basis of a resolution of the bar association without affidavit or anything is untenable, and even during the course of the proceeding, no opportunity is provided for. But I had on the last occasion submitted it for lordship that I will also cite some authorities on the point to assist your lordship to fortify my submission.
Yes.
With your lordship's kind permission, may I first of all, my lord, cite one authority which had the occasion to deal with this kind of circular, because in pursuance of the direction of the Honorable Appellate Court, the Honorable High Court of Uttarakhand, my lord, had issued also a circular, similar kind of circular, wherein this circular engaged the attention of the Honorable Court, and it was held that the proceeding being bad from the inception, having been not done with observance of the guideline, it was quashed. And I beg to cite this for your lordship's kind perusal and consideration. Then I will cite another authority on the point. Here, with your lordship's kind permission, may I first draw your lordship's kind attention to page 107? And
just a minute. Yeah.
My lord, your lordship will kindly peruse the guideline at page 107, Annex 3.
It is not reported anywhere in the.
My lord, in fact, your lordship, I have also got a document. Ministry of Justice, Union Government has also included this in their, my lord, website, and also this has been quoted in the other case which I have just cited. With your lordship's kind permission, may I just give the downloaded copy of guidelines of grievances? If your lordship will kindly
Yes, it is with us, and there is a circular too also, but thereafter another circular is there of Chief Justice.
Yes.
My lord.
After this, there is another circular.
My lord, here it has been mentioned, this is downloaded yesterday only. As per the guidelines issued by the Supreme Court of India, grievances against judicial officer are required to be sent on sworn affidavit with verifiable facts to the Register General of the concerned High Court. It is noting last, first page last 4 lines, your lordship.
Yes, sir.
I'm giving a copy to my learned friend also. Now, my lord, here, this is Annex 3, which I was citing, the guideline. Then I beg to draw my lord's kind attention to page 71, which in fact led to the initiation. That is annexure, that is resolution dated 9/1/2022.
71.
My lord, this is part of the charge sheet that was supplied to me, and this is what initiated the action. Your lordship will see page 72, SD President. There is no affidavit, nothing. Now, with your lordship's kind permission, may I place this authority on the point?
No, how do you say that on the basis of this particular document, the proceeding has been initiated against you?
That your lordship will
From
find
where we will
the
get it?
previous page 69.
Page
69.
Yeah.
The Secretary Judicial Bar Association writes to the Honorable Chief Justice of High Court of Orissa. With due respect, I, the Secretary of Bar Association, do hereby beg to submit on behalf of Judicial Bar Association Career, as that unanimous resolution was passed in the meeting of our bar on so and so, and the same is attached to it, and urge on behalf of the bar to conduct an inquiry over the matter and take action against senior civil judge Sri Santosh Kumar Agarwal, the petitioner, and for the same resolution is attached herewith. And on the basis of this was forwarded to the Disciplinary Court by the land district judge, and thereafter the action has been taken.
How do you say so?
That your lordship will find your lordship may kindly peruse letter dated 8/2/2022, that it has page.
No, this letter which you have page number 73. It is the letter issued by Special Officer Administration to the district judge that requesting to hold a confidential inquiry into the matter, and that was based on the resolution dated 9/1/2022 of the judicial. Okay. Then what happened?
On the basis of that, an inquiry was conducted.
Okay.
Then
what happened in the inquiry? What
the land district session judge report in page 74 to this honorable court.
And what is the operative part of that order?
Portion, your lordship, page 78.
78, yes.
All the above named advocates unequivocally stated for me that the senior civil judge career used language while sitting on the dais which is not tolerable and became unbearable to accept on their part. Mr. Agarwal doing half an hour court, even 1 hour by sitting on the dais, and used to gossip outside court matters. The advocates, namely so and so, have stated their personal experience, how they have been humiliated and do not care for the order passed by the honorable court in some BLFL matters by the senior civil judge in court. They all become annoyed about the behavior and comment passed towards the honorable court by the senior civil judge.
Okay, and it is then it is enclosed with 8 numbers of witnesses. Okay. Then what happened?
I was asked to also give a reply. I gave a reply, and thereafter the DP has been drawn. Under annexure, your lordship will kindly turn to page 41. This memorandum has been issued initiating the proceeding, enclosing the article of charges.
So let us be clear. It is not a case that bar sent a resolution to this court and this court initiated the DP.
No.
So the gap which is there, or the in between what has happened to ascertain the truthfulness of that allegations which has been imputed in that resolution, a confidential inquiry was conducted, and it was found that yes, whatever has been stated in that resolution appears to be prima facie correct. Okay. Then thereafter this proceeding. So this is the basic difference between the two. What has been prevented there, that if you get any such report which is having no affidavit, which is having no verifiable materials, then don't initiate a proceeding against the judicial officer. But once after getting the allegation, it was verified at the instance of, as per the order of the administrative judge, or maybe by the Honorable Chief Justice order, and the district judge inquired into the matter, examined the witnesses, and found, then how do you say that it was initiated merely because the resolution was given?
And that was the issue also in the decision I am citing before your lordship. The Honorable But your lordship will accept that view or not, that will be a different thing.
No,
But
no,
that was the case.
don't make a submission whether we'll accept. We are posing a question.
My humble
to
submission
you.
is when the very initiation is bad, even I can demonstrate from
It
record.
is no, it is not a that any what do you say that somebody just sent in an unknown name, that it came with the in the pad of the bar association. Bar association has forwarded, the secretary or the president has forwarded the resolution of the bar members to this court,
Right.
and this court try to know whether the whatever stated in that resolution, whether there is any sanctity in it, whether there is any truth in it or not. For that, a confidential inquiry was ordered. So, can you say that it is just without any basis that you are saying that merely because it was initiated without any basis, so the departmental proceedings should go?
But I am submitting rather, with your lordship's kind permission, that if the very initiation is defective,
Yeah.
then the collection of material will be irrelevant. It has to go. I'll just give one more example with your
Yeah.
lordship's kind permission. Recently, the Honorable Appeals Court had the occasion, but I'm pointing out whether the initiation is defective on that aspect. The Honorable Appeals Court had the occasion to deal with a case of Registrar of Chat against whom, in respect of an allegation which was beyond 4 years of his retirement, was the basis for initiation of the proceeding. Rejecting to the provisions provided in the Orissa Civil Service Pension Rule, which says if an allegation is beyond 4 years, no proceeding can be initiated, that proceeding was struck down despite availability of material on the basis of it, he was issued with a charge sheet. So what I humbly beg to submit
That is a
from that.
totally different. That is a different thing. That's a different thing.
My
That
that
has
was
been
also
limited
a,
because that is the statutory rule.
my lord, I'm not
It
disputing.
cannot have.
And here, my lord, your lordship will see the Honorable Uttarakhand High Court, while dealing with the matter, had the occasion to deal with a statutory rule available in respect of Uttarakhand.
In the Uttarakhand case which you are citing,
Ma'am.
is it a case where the bar association sent the resolution and on that basis the district judge held a confidential inquiry and thereafter the proceeding was initiated? And let us see it.
Yes.
Let us go to the factual. Please come to that.
May I just place it, ma'am? I was to place from paragraph 9, but first of all, I will place paragraph 2. In view of the
Yes, please.
clarification your lordship has been pleased to ask me.
No, because a little twist in the factual scenario may.
I have to assist your lordship
yes.
on the point. The facts shown of unnecessary details are that the petition was posted during the relevant period as District and Session Judge Chamoli, an undated anonymous complaint not supported by any affidavit allegedly made by the District Bar Association Gopeshwar at Chamoli was received by the High Court through registered post on 22/5/2023. The said complaint was sent to Register Vigilance, a sitting judge of the High Court by name, and subsequently to the Honorable Chief Justice of Uttarakhand by name. The Honorable Judge of the High Court marked the said complaint to the Registrar General on 22/5/2023. The complaint which was received by the Register Vigilance was what a copy. I'm sorry.
Yes.
The complaint which was received by the Register Vigilance was registered in the complaint register for judicial officers on 22/5/2023 at serial number 11. The Register Vigilance, after preparing a note on 23/5/2023, placed the complaint along with the said note before the Honorable Chief Justice. The Honorable Chief Justice directed the Registrar General Vigilance to forthwith gather material evidence to identify the courtroom, that is, whether the same is of DJ Chamoli, or if so, the particulars of the case in which the evidence is seen recording in the video clippings. This exercise should be done discreetly as far as possible. And further directed the matter to be placed before the Honorable Chief Justice with report within 10 days. The complaint which was sent and received by the High Court was an unsigned complaint from the District Bar Association Chamoli, in which a pen drive was also annexed, and the substance of the complaint was that the evidence was being recorded by the District Session Judge Chamoli against the procedure in the absence of the presiding officer, and it was alleged that it was the routine way of recording evidence in the court of the petitioner. The envelope in which the complaint was sent contained the name of one Hem Vasist, advocate, the court compound, Chamoli, mobile number so and so as sender. In compliance with the direction of the Honorable Chief Justice, purportedly, inquiry was conducted, and after preliminary inquiry, his explanation was called for by its show cause notice dated 11/7/2023, wherein the petitioner was called upon to show cause as to why disciplinary action be not taken against him for violating the direction issued by the High Court by order dated 3/10/2012 for recording the evidence of witness by judicial officers and not by Pescar. The petitioner submitted his explanation by letter number so and so, dated so and so. In his explanation, he stated that as the complaint was anonymous and without affidavit, the High Court should not take cognizance of such a complaint. The officer further stated that the video clip is nowhere disclosed its source. He further stated as to where is the original clipping. My lord, if your lordship permits me, I will skip that. My lord, then paragraph 6. After the receipt of the explanation, the petitioner was placed under suspension by the order dated so and so and Annexure 10 to the writ petition passed by Registrar General Uttarakhand High Court. The inquiry was shown to have been in contemplation against him. By the Annexure 12 to the writ petition, the charge sheet dated 10/8/2023 was issued against the petitioner, containing as many as 2 charges. The charge number 1 is about, my lord, that again, with your lordship's permission, I am skipping. Then, my lord, paragraph 7, your lordship, the petitioner submitted his written statement, which is also the case of the present case. Then now, my lord, your lordship, paragraph 8. The petitioner is now before this court challenging the suspension order, the charge sheet, as well as the entire disciplinary proceeding, mainly on the ground that the High Court should not have taken note of the anonymous complaint, which is unsigned, undated, and without affidavit filed in support thereof. Then, my lord, paragraph 9. In support, it is pleaded by the petitioner that the High Court issued a circular bearing number so and so dated 22/12/2014, whereby certain guidelines were issued by the respondent High Court on the basis of guidelines issued by the Honorable Chief Justice of India, New Delhi, in respect of complaints filed against judicial officer in the subordinate judiciary. According to that circular, a complaint made against member of subordinate judiciary in the state should not be entertained, and no action should be taken thereon unless it is supported by a duly shown affidavit and verifiable material to substantiate the allegation made in the complaint. It further goes on to say that if the action on such complaint meeting the above requirement is deemed necessary, authenticity of the complaint should be duly ascertained and further steps thereon should be taken only after satisfaction of the competent authority designated by the Chief Justice of High Court. It further goes to say as a caution that if the above requirements are not complied with, the complaint should be filed, lodged without taking any steps thereon. Then your lordship will kindly turn to paragraph 13. Paragraph 13, page 7, your lordship. According to the High Court, although the complaint was not accompanied by duly shown affidavit, the complaint was processed in accordance with Rule 9, Sub-Rule 4 of the amended rules, but there is no reference to circular dated 22/12/2014 in the counter affidavit of the respondent High Court. Now then, thereafter, your lordship may kindly turn to paragraph 28.
28,
your lordship. May I place it? Page 14, your lordship. From the appreciation of the aforesaid rules, there is no manner of doubt in the mind of the bench that this procedure prescribed under Rule 9 would come into play only when the complaint is once registered, and which complaint should be registered is given in the circular dated 22/12/2014, which is in clear terms says as follows. Your lordship will find the circular at page 107 is almost similar to the circular that has been quoted here in page 15. Then your lordship, paragraph 30 in the same page 15. From the perusal of record, it transpires that typed complaint was undated, unsigned, and not supported by any affidavit, wherein the name of the petitioner was written by hand in Hindi and was never placed after the registration before the administrative judge. Thus, the very initiation.
So just take pause for a moment. The complaint was undated.
Ma'am.
The complaint was unsigned.
Ma'am.
And not supported. Three things were there.
My lord.
Here it is dated.
My lord.
Here it is signed.
My lord.
Only affidavit is not there.
Affidavit is the requirement. So far as the circular is concerned,
no.
our circular and the circular at
Just,
page 15.
ତା ଧିରେ କ'ଣ ହେଇଛି
ସେଇଟା
ନା, ଏବଂ
ଲେଖିଛନ୍ତି
ଏଥିରେ
କିଏ?
yes, undated, unsigned,
Aye.
and not supported by. Yes.
Thereafter, the court has dealt with that issue
Proceed,
also.
proceed. Then, yes.
Right. Then, Your Lordship, my lord, page 17, paragraph 34. When the entire proceeding as discussed above has crumbled down due to non-observance of the procedure prescribed, and the very initiation of the disciplinary proceeding has been found to be not in consonance with the Uttarakhand High Court Vigilance rules, so and so, hence all subsequent consequent proceedings are vitiated. There is nothing left would allow the disciplinary proceeding to continue. Then, Your Lordship, page 41 and then 43.
41 and 43.
Ma'am?
41 and 43.
Ma'am.
Okay.
41, they have said that there is nothing.
Just a minute. Let us go to 41.
Ma'am.
Yes.
There is yet another aspect of the matter in the Uttarakhand High Court Vigilance Rules 2019. There is no mention anywhere in any of the amendments that the rules being notified in supersession of the earlier guidelines and circular. Resultantly, even if on the date the guidelines issued by the Honorable Chief Justice of India, on the basis of which circular dated so and so was issued, still holds the field, and the same cannot be bypassed while proceeding in a complaint against a judicial officer. Then page 43, page 20, paragraph 43. The writ petition is accordingly allowed. And I have skipped the facts. Your Lordship will see the contention also has been noted and the contention has been dealt with. And the other authority I was citing for your Lordship's kind consideration is on this technical aspect. My submission is if it is defective from the inception, that your Lordship, with your Lordship's permission.
PP number टा 22 ना. 3 आरो ये रिप्रेजेंटेशन टा ए जो आसीची जो 12 केबे सेटा जोटा
9/2022 your Lordship at page 71.
Just a minute.
Resolutions.
हाँ से resolution.
आगे
9/1/2022
সেটা ବି your Lordship page 49 ରେ ସବୁ list of document ଦିଆ ହେଇଛି ଯୋଉ ମତେ ଚାର୍ଜ ସିଟ୍ ଆସିଛି page 49 ରେ list of document ଅଛି.
ଏଠି ସେ 12 ଇଏଟା କାହିଁ ସେ ଯୋଉ ଷ୍ଟାମ୍ପ ଏ ଯୋଉ ପ୍ୟାଡ୍ ରେ ଯୋଉଟା ଆସିଥିଲା ସେଟା କେତେ ନମ୍ବର ପେଜ ରେ
ପ୍ୟାଡ୍ ରେ your Lordship
ପ୍ୟାଡ୍ ରେ ଗୋଟେ ଆସିନଥିଲା ଫରୱାର୍ଡ କରିଥିଲେ ମୋ ରିଜୋଲ୍ୟୁସନ ଟା ଦେଖଉଥିଲେ ପୁରା
page
ଆପଣ
69
ଓହୋ
69 ଆଜ୍ଞା
69
ମାଇଲ
ସେ କହୁଛ କଣ କହୁଛି ନା 69
ମାଇଲ ସେଟା ଏନକ୍ଲୋଜ ହେଇ ଫରୱାର୍ଡ
ହଁ ଏଇଟା ତ
ମାଇଲ
ଜୁଡିସିଆଲ ବାର ଆସୋସିଏସନ ଖରିଆ
ଆଜ୍ଞା
signature of secretary is there in 22/1/2022. The
Right.
date is there,
Right.
and members of the present in that meeting, that is there, and resolution has been passed, and
City SD
that is
72.
president.
And at
So-
para 10, also one of your complaint was that the veracity of the complaint has never been ascertained.
Married. But I am challenging on the ground of very initiation being defective. The other decision I was citing, your lordship will kindly peruse. Other decision just now I passed on, madam. ये place करी विषय तो पीछे. Madam.
All right, order is up.
And only that decision only. I'll just
Yes,
assist your lordship with few paragraphs, madam. I may be pardoned for that. I would just, what I take from decision to assist your lordship is that if the initiation is defective, it can be quashed. This is what I beg to assist.
That principle is all right, but
ପ୍ରିନ୍ସିପାଲ ଖାଲି ଏଥିରେ ବି ଟିକେ ଦେଖେଇବି ସେ ଆଲିଗେସନ ଟା ଏଷ୍ଟାବ୍ଲିଶ ହେଇକି ଚାର୍ଜ ହେଇଥିଲା ସେତିକି ଖାଲି ଦେଖେଇବି ଟୁ
Good.
ଦିସ୍ ଏ ଭେରି ସ୍ମଲ୍ ଜଜମେଣ୍ଟ
after 4 years, the
ନାଇଁ ଖାଲି ଆଫ୍ଟର 4 years ନୁହେଁ ମୁଁ ଖାଲି ଖାଲି ଦୀପ ଦଉଛ ଲର୍ସିସ୍ କାଇଁ
Yes, yes. Just show that.
Ma'am, a retired judicial officer of State of Orissa has approached this court by filing the writ petition under Article
yes,
30.
but this is permission.
खाली दी पद खाली देखिए
Hmm.
paragraph last paragraph is first page. The matter did not end at that stage. A fact-finding inquiry was initiated by the High Court on administrative side to examine the process of selection held, because the selection process on that ground he was proceeded against, seeking appointment to the post of caretaker initiated pursuant to an advertisement dated so and so. 2 days before her retirement, a letter number so and so is issued to the petitioner for the alleged irregularity committed in the process of selection held to the post of caretaker, and later a charge sheet dated so and so was served upon her. Then I'll skip everything. Only that page last, the rule that has been quoted, sub rule, clause 2, Roman 2, which has been highlighted, shall not be in respect of any event which took place more than 4 years before such institution. And that has been taken note of, and it has been quashed, directing that petitioner should get all benefits. The purpose of citing this decision is, if the initiation is defective, it can be interfered with. That is the only purpose for which I am citing, ma'am. I am grateful, my lord, for giving me a patient hearing, ma'am.
Yes.
Ma'am.
Absolutely. So,
My lord, that OJS matter may kindly be.
Item 33,
Pardon to mention, my lord. Item number 57 of today's list.
57?
JCRL 57. JCRL number 24 of 2024. In this case, I was appointed as a amicus, my lord. But since this is a case where the appellant has been convicted under section 302, in a previous case, I was disengaged by
Because of the less
unocular judgment, my lord.
Hmm.
Similar orders, lordship may kindly pass.
Engage any other lawyer.
My
अच्छा होटल को दे देगा सर को दे देगा सर जाओ करके दे दो डॉलर
grateful, lords.
For me to mention, my lord, appellant is custody more than 12 years.
give it
Lordship, I was given the paper book and the judgment copy. I
Ah,
may be permitted to
ah,
give this.
yes.
କିଏ ଅଛନ୍ତି ଆସ ଯଦି ଅଛନ୍ତି ଡାକିଲ ହଁ ଡାକୁନାହାନ୍ତି ଡାକନ୍ତୁ ସେଭେନଟା ହେଇଛି 1/8/2023 ପାଇଁ ଏଇଟା ପୁରା ଗଲାଣି 12/8 କଣ ତମେ yes next ଡାକ ଆଗ ସିଏ ଶାଶୁ ମାନେ ଆଜି ପାଇଁ ରଖିଥିଲେ ହିସାବ ଲେଖା yes you are there
Item 10, my lord.
what do you say
Other councillor not there. They are associated there.
Mr. Pandit,
yes
Your lordship directs the state council to obtain instruction from the PS regarding criminal antecedents or other.
yes Mr.
Yes.
Please have you got a copy of that
Yes, yes.
please place it let us see that
Reference to the above subject and the reference I am to comment that I have conducted local inquiry and it is ascertained that one, the deceased Keshav Behera, son of late Mohani Behera of Sheikh Bazar, P.S. Lalbagh district, Cuttack, was the secretary of Sheikh Bazar Puja Committee, Vice Secretary, as well as the Vice President of Mahanagar Shanti Committee, Cuttack, at the time of his murder. Second, the accused person named Vishwanath Behera Vela, Deborah Behera alias Vishnu, Keshav Behera alias Mantu, all are son of Bongali alias Dinobandhu Behera of Sheikh Bazar, P.S. Lalbagh district, Cuttack, and S.K.Sahoo alias S.K.Sahoo, son of Alia of Macallan, Odia Bazar, P.S. Lalbagh district, Cuttack, are residing in the same site and attested site respectively. The accused person were the supporters of which members of noted gangster Tito. They had no specific occupation and they were maintaining their livelihood by extortion and antisocial activities, etc. In past, they were known as local gunda, and out of fear, the innocent local people dare to raise any voice against their criminal activities. The famous festival of Kotak like Ganesh Puja, Durga Puja, Kartikeshwar Puja, and Bali Jatra will be celebrated ahead. If the accused person released on bail, they may involve themselves in demanding booty and may commit antisocial activities to prove their existence, for which there is every possibility of law and order situation in the future. Right. During the inquiry, it is also ascertained that after the murder of Keshav Behera, the local Sahi people as well as the family members of the deceased Keshav Behera were shocked and apprehensive. If the accused person released on bail, they will not accept the presence of the accused person in their locality, which may lead to the group class law and order situation, bloodshed and loss of life in the future.
So, let us go one by one. A1 is Vishwanath Behera.
The other day I have submitted the criminal antecedent.
Huh.
Already filed.
সেটা
That.
ক্রিমিনাল অ্যান্টিসিডেন্টটা দিয়েছিলে huh. So this A1 Vishwanath Behera has got 3 criminal antecedents,
Including this case.
including this case. There are 2 criminal
Two
antecedents.
cases, out of which in one case is acquitted, in another case is on bail.
That comprehensive affidavit you have filed.
Filed.
Okay. Now number 2 is
Keshav Behera, alias
appeal memo টা কেন? Okay.
first case my lord.
A2 is Keshav Behera. Alias Litu. Montu.
Yes.
Acha, Montu, huh. Okay.
First case is the present case.
You have also furnished the custody certificate of
Yes,
all. So Montu has got 5, including this case.
Including this.
Okay. Then the number 3 is A3,
Only this case.
Devraj.
He has no antecedent.
No antecedent. Devraj Behera, no antecedent. And DA4,
8 including this.
S.K. Rahul. Okay, C.DASH. 8 including this case. Okay.
Actually, there are 8 cases, but
Yeah.
where I have been acquitted, can they be termed to be antecedents?
It's all right. How many cases are instituted? He has not mentioned, but you have mentioned that in how many cases they have been acquitted,
Yes,
right?
I have mentioned.
Okay. So, what is their period of detention virtually prior?
11 years.
In an average, it is. Where is that custody certificate of all the?
10 years, 9 months, 24.
ସମସ୍ତଙ୍କର?
That is
15-20 ଦିନ ଅପେକ୍ଷା ପାଖ।
ଆମର ଜମା ବାହାରନି।
Rahul. Last.
So everybody has remained in custody for more than
10 years.
This is one Vishwanath. Vishwanath ର custody certificate ଆପଣ ଦେଇଛନ୍ତି, it is 11 years. अच्छा. Then ସବୁ ଗୁଡାକର custody certificate ଅଛି ଦେଖିଲ?
1, 2, 3 apprehended in the same day.
Yes, 1 to गला 11 years. 2, 3 and 4.
Or I don't. My learned senior can say 1, 2, 3.
10 years, 9.
And 1, 2, 3. All brothers. All are brothers. One
No, brothers, mane,
Same day.
same day. Okay.
Same. 11
So
years of
1, 2, 3, 11 years, and 4 is 10 years, 9 months, right? And here is a case where paper book has been prepared or not prepared?
Matter has been hard in fact.
Acha.
Long years back.
Uh-huh.
In 2018.
Mm-hmm. 2018?
Yes.
The author of order.
That is Vinod Prasad.
It's
There is one other thing your lordship can take note of.
Mm-hmm.
With regard to the affidavit which my learned friend had.
Mm-hmm.
So far as the person who has the absconder, in this case who is facing a separate trial, he is on bail since 13th of February 2022.
Absconding accused.
Yes.
যে বর্তমান ফেস করছি ট্রায়াল।
Right. I have a copy of the order. And his presence creates no problems. No.
Other of the plan for 1, 2, 3.
He has been acquitted.
Was also
In fact, Mr. Panda, we are searching for those orders where you say that it was hard on merit, but the order sheet does not indicate that. In 2018, you said.
He was arguing that matter.
Okay.
Price or
2019, it is already there. 2018. 18 तक total 18 नो किसी order ही नहीं 2017 ପରେ 35 number 36 number order ଆସିଛି
I am sorry.
2019
The hearing occurred in the year 2016. Your lordship may see order dated 2/11/2016 onwards.
2/11.
Yes. It started on 2/11/2016 and was adjourned to
that is there. That is
3/11, 7/11, 4/11, 7/11, 8/11, 9/11, 10/11, 11/11, and then it was adjourned to the first week of December.
Not treating it to be tied up
Yes.
with this message. Achha. And eyewitnesses are there. You are placing that evidence, Mr.
Yes. There are eyewitnesses. But
that is gunshot injury, no?
Yes.
Gunshot. Who are the eyewitnesses?
9, 13 and 19.
PW's 9, 13 and
19.
And doctor conducted PM.
Postmortem doctor is PW1.
PW1. नहीं तो PW1 नहीं
18 years.
PW1 doctor.
18.
No, he's not the postmortem doctor.
He is the emergency medical.
PW18.
18. Dr. Auburn.
Puncture lacerated wound, so and so. Okay. What they were, the deceased was going somewhere. You placed that judgment on that day. He was going and these persons
ଚଣ୍ଡୀ ମନ୍ଦିର ଯାଉଥିଲା ଚଣ୍ଡୀ ମନ୍ଦିର ଯାଇକି ଫେରୁଥିଲା
towards the house Sheikh Bazaar in Honda Activa scooter on the way near Devigar, so and so came in 3 motorcycles chasing him, so and so fired Answer. Okay. So, just council name we want to take, Mr. Let us take the names. Appellant number 4 is Mr. Devasis Panda. And then appellant number 1 is S.K. Jaffrullah. Then A23, Mr. Naik.
Yes.
Karunakar Naik. All right, we pass the order. Yes. Next. Letter of the- Mr. Pradeep Kumar Pradhan. Not there. 21. Mr.
May I please, my lord?
Yes.
Your conviction is under section 376D and read with section 6 of POSCO Act, but conviction has been made under section 376D, and petitioners are in custody since 8 years, 9 months, 4 days for order dated a report called on dated 5/7/2014. Report ଆସିଛି ସେଇଦିନ they are in custody. So far
15/7.
my lord 5/7 ଆସିଛି certificate custody certificate ଆସିଛି. Must have been ଦେଖିଲେ record.
Yes.
Court record probably there is custody certificate.
It is 8 years, 9 months and 4 days.
My lord.
That is there.
So far prosecution case is concerned, the informant number 3 lost the affair that her daughter had gone to purchase books and she missed. Thereafter 3 days she rescued by the police.
It's a case of gang rape.
My lord.
So who is the victim?
I want to draw the attention of my lord to the PW5, my lord.
PW1 is the
Victim, but I want to draw the attention of this honorable court to PW5, the
Doctor कितने?
PW5.
PW5 की है?
Doctor, my lord. Jyotsna Sahu. On 1/10/2015, I was posted to medical officer at CHC Raikia. That day at about 2 p.m. on police requisition, I examined the victim PW1, identified by the lady constable Purnima Pradhan, and found the following. There is no bodily injury, suggesting forcible sexual intercourse or wearing clothes did not give any Montu, Chiku, GI.
run. Best one. Item number 2 to 2 number accused again. Subbal Diggle. 3 number. এটা হলা 3 number চিকুন প্রধান 3 number হচ্ছে লোকনাথ ভোই. It is you,
My lord.
right?
My lord.
Then 4 number 4 number হলো সঞ্জয় নায়ক.
He is the main accused, my lord. Sanjay Naik.
সঞ্জয় নায়ক. Then ଆଉ କିଏ ଅଛନ୍ତି? ପାଞ୍ଚ ନମ୍ବର ହେଲା ବିଷ୍ଣୁ ପ୍ରଧାନ.
ତାହେଲେ ଏଇଟା ବୋଧେ ଜୁଭେନାଇଲ ଟାଇପ.
କିଏ?
4ଟା ଏକ୍ୟୁଜ ଗୋଟେ ଜୁଭେନାଇଲ ଥିଲା.
ହଁ 5 ଜଣଙ୍କ ନାଁରେ ଚାର୍ଜସିଟ୍ ହେଇଛି, ରାଇଟ୍? 5 ଜଣଙ୍କ ଭିତରୁ
4 ଜଣ ଯଦି ଏଠି ଅଛନ୍ତି
ହଁ
ନାଁଟା ଜୁଭେନାଇଲ ହେଇଥିବ ସେ 4 ଜଣଙ୍କୁ
ବଟ୍
ଆଇଡେଣ୍ଟିଫାଇ
ୟୁ ସି ନାଇଁ ଆପଣ ଆଉଥରେ ଆସନ୍ତୁ PW1 ର ଏଭିଡେନ୍ସ. ସେ ସ୍ପେସିଫିକ କହୁଛି ସଞ୍ଜୟ ଆପଣଙ୍କର ଆକ୍ୟୁଜଡ ଅଛି.
My lord.
ଦିସ୍ ମ୍ୟାନ୍ ଇଜ ନଟ୍ ସଞ୍ଜୟ.
No.
ତାପରେ ବିଷ୍ଣୁ ବି ଅଛି ଗୋଟେ ସେପାରେଟ ଆକ୍ୟୁଜ.
ଆଜ୍ଞା.
ତାପରେ ରହିଲା ସୁବଳ ଗୋଟେ ସେପାରେଟ ଆକ୍ୟୁଜଡ ଅଛି.
My lord.
ବାକି ରହିଲା ଚିକୁନ ଆକ୍ୟୁଜଡ ଅଛି. ତାହେଲେ ସେ 4 ଜଣଙ୍କ ନାଁ ସେ କହୁଛି ଯେ ଏଇମାନେ ହିଁ ପ୍ରେଜେଣ୍ଟ ଥିଲେ. victim properly identified these accused person. That means what does it mean? The victim has not identified the present petitioner.
ଯଦି ଜୁଭେନାଇଲଟା ହେଇଥିବ ସେ ଟ୍ରାଏଲ ହେଇନଥିବ.
କିଏ juvenile? ये petitioner is a juvenile.
ହେଇଥିବ କିନ୍ତୁ 5ଟା ଏକ୍ୟୁଜ
ହେଇଥିବ ଆପଣ
4 ଜଣଙ୍କୁ ଆଇଡେଣ୍ଟିଫାଇ କଲା ଜଣେ ଜୁଭେନାଇଲଟା ସେ.
The name of the petitioner is
Loknath.
ମାନେ ପାରା 2
ଲୋକନାଥ ପୁରା ଭୋଇ ପୁରା accused number 2 ଅଛି.
And he has been examined and 313 whose age is 22.
ହଁ ସେ କୋଉଠି juvenile juvenile ହେଇଥିଲେ ସେଠି କାହିଁ ସେ ଆସିଥାନ୍ତା?
Loknath who is son of Sudarshan.
ହଁ. So that is not so. That means the victim in court, if you just placing, victim has identified only 4 persons. He says Sanjay noticed me. Then Sanjay, Vishnu, Subal, Chikun are very much present in this court. The victim properly identified the accused persons in this court. Accused Sanjay compelled me to go Udayagiri. He told me until and unless I did not accompany him, he would kill me. Accordingly, I went with Sanjay, so and so. Then Sanjay did this. Sanjay made a telephonic call, namely Mantu, Chikun, Vishnu, and one JICL. अच्छा JICL माने है जो juvenile टाइप. अच्छा. Accordingly, the accused Mantu, Chiku, नहीं इसरा Jikki actually JICL में Jikki and Vishnu arrived at the spot. Accused told them so and so. Thereafter, the accused persons told. So, where is the material against the petition? No, let us see that whether on that particular day this man was present in the dock or not. That is on 18th April 2016. Order sitta bar kara. Order 4/4/2016. Order number 20. Right? Accused persons are produced in custody. ସମସ୍ତେ custody ରେ ଥିଲେ. The Land and Special Public Prosecutor, the Land and Defense Counsel present. ତେଣୁ ଇଏ କେହି ପ୍ରଡ୍ୟୁସ ନ ହେଇଛନ୍ତି ବୋଲି ଇଏରେ ନାହିଁ, ସମସ୍ତେ ପ୍ରଡ୍ୟୁସ ହେଇଛନ୍ତି ଏବଂ ଆଇଡେଣ୍ଟିଫାଏ କଲା କେବଳ 4 ଜଣଙ୍କୁ. ଆକୁ ତ ଆଇଡେଣ୍ଟିଫାଏ କଲାନି ଏବଂ ସ୍ପେସିଫିକ ନାଁ ଧରିକିନି କହିଲା ଯେ ଏଇମାନେ ହିଁ କଲେ.
ଏଇଟା ମୁଁ JICL ବୋଲି ଭାବିଲି. ଏଇଟା ଜିକି.
ନାଇଁ ସେଟା ଜିକିଟା ହଉଛି ଆପଣଙ୍କର ୟା ନାଁ ବି ଜିକି ନୁହେଁ ଆପଣଙ୍କର. ଇଫ ୟୁର କେସ୍ ଇଜ ଦ୍ୟାଟ୍ ହି ଇଜ ଅଲସୋ ନୋନ୍ ଆଜ ଜିକି, ଆପଣ ଏଭିଡେନ୍ସ ଆଣିବେ. ଭିକ୍ଟିମ୍ ନିଜେ କୋର୍ଟରେ ଆଇଡେଣ୍ଟିଫାଇ କରୁଛି 5 ଜଣ ଛିଡା ହେଇଛନ୍ତି, 5 ଜଣ ଗୋଟେ ରୁ ସେ 4 ଜଣକୁ ହିଁ ଆଇଡେଣ୍ଟିଫାଇ କରୁଛି. then it presupposes that he's not telling anything against the petitioner.
That is how it's nine.
Okay. ଏବେ ଚିପରେ ଚାରିଜଣ ସ୍ପେସିଫିକ କହିଲା ସେ ଏଇମାନଙ୍କୁ ଡାକିଲା ଏମାନଙ୍କ ଭିତରୁ ସମସ୍ତେ ଖାଲି ଏଇ ଆ ନାଁଟା ନାହିଁ ଆଉ ସମସ୍ତଙ୍କ ନାଁ ଅଛି ଲୋକନାଥ ବହି ନାଁ ଅଛି ତମେ ଦେଖିସାରିବ ନାହିଁ Sanjay
Then how you have been included as a, and conviction is there.
Yes, my lord. Live conviction.
What is the basis then? Find out. What is the basis?
Basis ଆଉ କିଛି ନାହିଁ judgment so far judgment is concerned basis ଆଉ କିଛି ନାହିଁ ଯେ ସଞ୍ଜୟ ପରେ ଏମାନେ so and so done the such a work on that basis they have been convicted.
It's ଏଇଟା victim ଏଟା କହୁନି ବୋଲି ଇଏ judgment ରେ କଣ ଲେଖିଲେ यार ନା ତ ନାହିଁ
ନା judgment ନା ନାହିଁ
ଲୋକନାଥ
ସେ ଖାଲି କହୁଛନ୍ତି conviction ଟା ସଞ୍ଜୟ ଉପରେ analysis କରିକି such and such judgment of the Supreme Court statement of the victim is sufficient to
ଗୋଟେ ଛିଡା ବି ହେଇଥିବା ଦରକାର ତ ଭାଇ ନା ଏଇ ଲୋକଟା ଏଇ ଜାଗାରେ ଛିଡା ହେଇଥିଲା ଯେତେବେଳେ ଘଟଣା ହେଲା gang rape ରେ all may not be in action but if a person is standing there
standing କଥା FIR store ରେ ନାହିଁ ତାପରେ 164 ରେ deposition ରେ ବି ନାହିଁ 164 ରେ ନାହିଁ allegation ହଉଛି he called to other four person who committed such action one after another and she has stated the name
କାରଣ ଏଇ ଯୋଉ paragraph 2 ରୁ ଟିକେ clear ଆସୁଛି ଦେଖନ୍ତୁ thereafter Sanjay made a telephonic call to accused persons namely ଏଇମାନଙ୍କୁ ଏମାନେ ଥିଲେ ତିନି ଜଣ dock ରେ ଥିଲେ but one ଜିକି ଯୋଉଟା କହୁଛନ୍ତି ସେ ଜିକିଟା obviously ଏଇ ଯୋଉ ଇଏ ଲୋକନାଥ ନୁହେଁ ପିଟିସନର ନୁହେଁ ତେଣୁ ଜିକି somebody else maybe that Jiki is that juvenile jota ko apan kouchanti maybe that is the so rightly the question has been asked to you how the petitioner then if the victim has not named the petitioner not identified him in court not alleged anything against him who else has stated against the petitioner for which you have been sentenced to life imprisonment.
So far there are 8 witnesses, my lord. So far there are 8 witnesses. No witnesses have stated my name, my lord.
164?
I have 164. Yes. There is also
ଆଉ ତ କିଛି ନାହିଁ evidence ଦେଖିସାରିଲୁଣି
164 ରେ କାହା ନାଁ କହିଛି
ସେଇମାନଙ୍କ ନାଁ କହିଛି
ସେ ଚାରି ଜଣଙ୍କର
my lord I am
ଦେଖିଲେ
There are 161. Montu, Vishnu, Chikun, Subol.
ଚାରି ଜଣଙ୍କ ନାଁ 164.
ଚାରି ଜଣ ନା very clear. ଚାରି ଜଣ ଯାକ trial face କରୁଥିଲେ along with the petition. Mr. You see the 161 statement. ଏତିକି ବେଳେ ସଞ୍ଜୟ ଅନ୍ୟ ଚାରି ଜଣଙ୍କୁ ଡାକିଲା ଆରେ ମଣ୍ଟୁ ବିଷ୍ଣୁ ଚିକୁନ ଓ ସୁବଳ ଆସ then you did this then they came and same thing which he has stated neither he has stated the name of this petitioner nor identified so and other witnesses there is nothing we have also he is rightly telling that no other witness has stated anything
Judgment also nowhere it has been stated.
During course of investigation, the complainant, other witnesses were examined and this court is visited. The accused persons, Sanjay Nayak, Vishnu Prasad Pradhan, Tinku Pradhan, Subala Tika. ଚାରି ଜଣ
ସେ ଚାରି ଜଣ ତ ଅଛନ୍ତି କେସ୍ କରୁଥିଲା are the learned counsel for the petitioner, the learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody for more than 8 years.
My lord, 8 years, 9 months, 4 days.
More than 8 years, 8 years, 9 months, which should be evident from the custody certificate issued by the superintendent sub-jail G. Udayagiri. It is further submitted that neither the Sanjay Naik, she's a criminal.
The main accused, my lord. He called and he taped thereafter others.
Sanjay Naik, he learned counsel submitted that neither the petitioner has been named as an accused by the victim in court, nor he has been identified in doc as an accused, and the evidence of the victim would indicate that accused persons Sanjay, Mantu, Chiku, Jiki, and Vishnu committed the crime. No other witness has implicated the petitioner in the crime, and therefore the petitioner has good chances of success in the case, and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state placed the evidence of the victim PW1 and also the evidence of the doctor PW5, who has stated that there was no bodily injury suggestive of forcible sexual intercourse and no sign and symptoms of recent forcible sexual intercourse, and that the victim was habituated to sexual intercourse and the hymen was ruptured. Needless to say that the occurrence in question stated to have taken place on 29/9/2015, and the doctor PW5 examined the victim on 1/10/2015. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, since it appears from the evidence of the victim that she has neither named the petitioner as an accused nor identified him in court during trial, and no other witness has stated anything against the petitioner, taking into account the period of detention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Lekhi diyantu, he shall not try to come in contact with the victim or any family member, shall not try to indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail.
My lord, I'm sorry to mention. I was absent. Simply your lordship may noted my presence. Otherwise,
No, and the report that has come, they have stated that since the puja is coming, like Ganesh puja, Durga puja, and Kartikshwar, if these persons are released, then there would likelihood of swan. So that is the report he has furnished. Mr. Tripathi has.
I only request on the court to record my
Yes,
presence.
definitely will do. Yes.
The conducted appeal CRA 288 of 2018.
You have been named.
Yes.
You have been named, Mr. and identified in court by the victim in a case of gang rape.
Only my respectable submission, my lord.
Yeah.
Regional petition that should be accepted and a custody certificate be called for. I will.
All right, learned counsel for the business petition kahin
I will.
engage. देखिए अच्छा তাহলে CRL number 288 of 2018 এর লেখন তো prisoner's petition has been received for engagement of Mr. Rajiv Bihari Misra as his advocate. Mr. Misra has filed vnama which is accepted. The names of other counsel except Mr. Rajiv Bihari Misra and his associate shall not be reflected in the cause list henceforth. Miss case number 709 of 2018, stay of realization of fine allowed. Miss case number 708 of 2018, application for bail. London Council for the state seeks some time to produce the custody certificate and also obtain instruction regarding criminal antecedent, if any, against the petitioner. Put up this matter 2 weeks after. এটাও যে সেকেন্ড উইথ যে এইখানে আসছে CRL এ 200
Participate to
yeah 2 weeks after we'll give a date but (34) Mr. Vishwaranjan Dole. ଆଉ କାଲି ଅକ୍ଟୋବର ଡାକିବନି ମାନେ ବାରମ୍ବାର ଡକ୍ଟର ଯୋଉମାନେ ନ ରହିଛନ୍ତି ଆଉ ଡାକିବାର ନାହିଁ ହେଲା ୟେସ୍ ଯୋଉଠି ଯଦି କାଲିକି ସ୍ପେସିଫିକ କିଛି ଆର୍ଜନ ହେଇଥିବ ସେଇ ଗୋଟାକ ଡାକିବ ଅଦରୱାଇଜ ୟେସ୍
He is the appellant convicted under section 302, my lord.
which is the item 35
My lord.
yes
Is the appellant convicted 302 of IPC and arrive for life and 5,000 rupees fine, my lord. Custody since 12/9/2015, my lord.
custody certificate আসছি
Okay. Entire case is based on.
and what about the CA
that is also not
the IN number 2621 of 2023. This is an application for bail. London Council for the state seeks some time to produce the custody certificate as well as to obtain instruction regarding criminal antecedent, if any, against the petitioner. Hala, list this matter. Gote saptah par bar puro ki diyantu. Hala, yes. Mr. Pushpamitra, এটা কালি বি ডকা ইতলা নথিলে ছাড়ো নেক্সট हाँ पाइले कि विश्वजीत त्रिपाठी की
today also my manager
Today also he called.
he is telling me I am coming but nobody is
नहीं
he has not
एंगेज कर दे कि उसने এটা সারଙ୍କୁ ଦେଇଦେବେ ସାର୍ ଯାହାକୁ ଏନଗେଜ କରିବ ତ ନେକ୍ସଟ ସେତିକି ନା ନାଇଁ ନାଇଁ ଟାଇମ ହେଇଗଲାଣି you have to ହଁ ନାଇଁ ନାଇଁ ସେ ହଉ ତ